There she is. I see her.
Okay, let me track
And then
Officer.
Detective, I don't know if I'm saying it correctly, Nazirovich. I'm sure I'm butchering it.
All right. Officer Jones, can you raise your right hand, please? Do you swear or affirm your testimony will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. Go ahead, Ms. Carter.
Thank you, Judge. Officer Jones, you're with probation and parole in Simpson County, is that correct?
Warren County.
Warren County, I apologize.
That's okay.
Are you currently supervising Keisha Parks?
Yes, I was.
When did you begin supervising her?
Let's see. Around February 12th, beginning of February of last year.
Okay. At the beginning of February, as a condition of her probation, was she to complete a treatment at House of Change?
Yes.
And could you tell the court, did she do that successfully?
She did not.
What happened?
She was, let's see. She was kicked out of or discharged from House of Change. They said she had used, I had drug tested her, she was clean. She then went to the Freedom House and got a bed there.
When was that?
That was in the beginning of May.
Okay. How long did she stay at the Freedom House?
Technically, she was only there for like a month or so before she told Freedom House she was staying at the hospital with her father. But I never received any documentation. The only documentation I received from that was from the Freedom House, from Karen at the Freedom House. She got a letter from the hospital stating that Ms. Parks was going to be sitting with her father. But Ms. Parks did not provide me with that letter. On May 12th, she stated she was at the Freedom House. On the weekend of May 25th, that is when Karen at the Freedom House received the letter from Veterans Hospital in Louisville stating that Ms. Parks was staying with her ill father at the hospital. At that time, Karen reported to me that all of Ms. Parks' belongings were still at the Freedom House, and her rent was paid up, but she had not been on June 30th, she said all of Ms. Parks' stuff was still at the house, but she had not been there since the end of May. And then over the next month through June and July, I played phone tag with Ms. Parks. I was never able to get a hold of her. She would call me back, and then every time I would try to call her back, or she didn't have a phone, and I would try to call the hospital or something like that, where her father was supposed to be, I could never get a hold of her.
At any time, like over those months where you were playing phone tag, was she supposed to report in person to you, or were you just maintaining phone contact?
We were just doing phone contact because it was in the middle of COVID.
Okay.
But let's see. When I spoke to Karen at the Freedom House, she said there was 3 different times that Ms. Parks was supposed to return to the Freedom House. And each time Ms. Parks never came back. And then when I wrote this violation in August, I had called the Veterans Hospital in Louisville to see if they had a patient named Larry Parks. That is who Ms. Parks was supposed to be sitting with. And they stated at that time they did not have anyone named Larry Parks. And I had not spoke to Ms. Parks in a while since then.
Is she still on your caseload? Technically,
Yes. When she got
And-
picked up, she got put back on it.
Okay. And when she was arrested in August, you were aware of that new offense.
Yes.
Since that time, has she maintained contact with you like she should?
No, I have not heard from her.
Okay. I have no further questions for Officer Jones.
Okay, Cross?
Yes, Judge. Do you know, did they give you any kind of discharge information on her dad, like when he would have been discharged or anything like that?
No, I have no proof other than the letter that Karen sent me from Freedom House that her dad was even in the hospital.
Okay. Okay. Would they have given you that information anyway?
Probably not.
Okay. So she went to House of Change and was there, did you say about a month? And then transferred to this
She was
Freedom?
there for about 2 to 3 months, and then she got kicked out of there and went to Freedom House.
Okay, what is Freedom House? What is that? Is that like a halfway house or is it?
It's a sober living home in Bowling Green.
Okay. How long are you supposed to stay there? Do you know?
It's usually 6 months to a year.
Okay. And she was at that place for what, a month or two?
About a month, yeah.
Okay. When Miss you started seeing Miss Parks in February 12th of 2020, she was put
Yes.
on your caseload?
Yes.
Okay. And when did she go to this House of Change?
She was there. That's when I accepted her transfer. I spoke to Nick Hudson at House of Change, and he stated she was there. And
When was that?
I spoke to Nick Hudson on 2/12, and then she actually reported to me in person on 2/13.
Okay. How many times did she report to you while you were supervising?
Well, in April, we did start phone reporting, so then it got a little different than normal, but she reported February, March, April, May again. So last time I talked to her was May 20th. Her next report day was on June 3rd. I tried to call her multiple times, couldn't get a hold of her. That's when I was talking to Karen at the Freedom House. She left me messages twice in July, and every time I tried to call her back, she didn't answer.
Okay.
Yeah, that's the last time I officially talked to her.
In June of 2020. Is that correct? June of
It
2020?
was May 20th of 2020.
Okay. Did you, were you drug testing Miss Parks during the times that when she was coming to your office, when you were meeting with her?
I tested her, it looks like, I think the one time after she got kicked out,
Okay.
due to COVID, that was right in the middle when the office shut down, everything kind of shut down. And so we weren't having people come into the office.
Okay.
Our office wasn't even open for a couple months.
Okay. So you did test her one time?
Yes.
Okay. All right. What, was she negative on that test?
Let's see. I tested her on 3/12 of 2020. It was positive for meth, but then when it came back from the lab later that month, it was negative.
Okay. this new case she has down in Simpson County, I don't guess you know any of the details of it. You just know what she's charged with.
Yeah, I just know what she was arrested on.
Okay. How was she supposed to report to you during these past few months? Just by telephone or what?
What do you mean the past few months? Since she got out of jail for her new charges?
Well, since you said you hadn't seen her or hadn't talked to her since back in June or May of this last year.
She was supposed to call me on June 3rd. And for a while it was through phone, and it's still through phone for the most part now, but we can have people come in as needed if we needed them to. But I haven't, even after she got out of jail in August from the new charges in Simpson County, she hasn't contacted me.
Okay. That's all the questions I have, Judge.
Very good. Ms. Gardner, redirect.
I don't have any questions for her, Judge.
All right. May we excuse this witness?
We can.
All right. Thank you, ma'am.
Thank you.
Ms. Gardner, any other proof?
I do have Detective Nazirovich.
All right.
If I could ask him how he pronounces his last name.
You're pronouncing it correctly, ma'am.
Okay,
Okay.
good.
Can you hear us, sir?
Yes, sir. Yes, Judge.
All right. Will you raise your right hand for me, please?
Yes, Judge.
Do you swear or affirm that your testimony will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Judge.
Okay. I was asking that question because your camera isn't on, and you may not want it on, but I couldn't tell if you were looking at us. So we're good. Go ahead, Ms. Gardner.
Thank you, Judge. Detective Nazirovich, you're employed with is it the Simpson County Drug Task Force?
The South Central Kentucky Drug Task Force, ma'am.
Okay. And on August 7th of 2020, did you arrest Keisha Parks?
Yes.
Could you please tell the court a little bit about what happened that day and what you ultimately charged Ms. Parks with?
Yes. So on that particular day, we had arrested a subject that I'm going to call a cooperating witness. His name is in the discovery that's going to be provided to Ms. Parks. But we arrested that subject with approximately 1 ounce of suspected methamphetamine. He would then in turn choose to willingly cooperate with the task force. He agreed to reach out to drug dealers to purchase methamphetamine, and he used his own cell phone and made contact with Ms. Parks. He spoke to her via Facebook Messenger and phone calls. Ms. Parks agreed to sell him 1 ounce of methamphetamine, and she also wanted a Percocet pill that he had. They agreed to meet at a predetermined location in Franklin. They agreed to meet at the Five Star gas station, which is located on 31W North, Bowling Green Road. Ms. Parks told us which vehicle should be, or she told our cooperating witness which vehicle should be arriving in, and we identified her through the witness and Facebook. We had an agent in an unmarked vehicle in the parking lot of the gas station, and the target vehicle was observed pulling into the gas station parking lot. We made contact, and I identified Ms. Parks as the sole occupant and driver of the vehicle through the Facebook pictures. When we made contact with her, she stated that she had the drugs in the vehicle. We then searched her vehicle and located approximately 1.5 grams of suspected meth. We located suspected marijuana and suspected cocaine. Agents also located several clear empty baggies similar to the ones that the drugs were in. The methamphetamine, or the suspected methamphetamine, was split up between 7 different bags. Ms. Parks was transported to the Simpson County Sheriff's Office, read her Miranda warnings. She agreed to speak to me at the Sheriff's Office. And basically, in summary, she agreed to meet the cooperating witness at the gas station to sell him the methamphetamine and to get the pain pill from him.
Judge, I have no further questions for the detective.
All right. Mr. Barry Cross?
No, Judge, I don't think I have any cross-exam at this time on that case.
All right. Very good. May we excuse this witness?
Yes, sir.
All right, sir, you're free to go. Thank you for your time.
Thank you, Judge. Have a good day.
You too. Ms. Gardner, is that the proof for the Commonwealth?
It is.
Mr. Berry, do you have any proof that you wish to put on, sir?
Yeah, I'd like to call Ms. Parks.
Okay,
Oh, no, Judge, I'll withdraw that, not with that felony pending down there in Simpson County.
understood.
Ms. Parks can testify if she chooses to, but I'd advise her not to if she wants to listen to me on that.
There's a first time for everything.
I know.
I don't really have nothing to say. I mean, my dad was sick, but besides all that,
Okay, well, wait a minute. Judge, I want to put you under oath if you want to testify.
Yeah, if you want to testify, then that's fine, but you'll have to do it under oath and be subjected to other questioning from the Commonwealth. So your attorney is suggesting that you exercise your constitutional right to remain silent.
I agree.
All right,
Okay, Keisha.
Barry, you want to make an argument there?
I do, Judge. I would ask the court that Keisha's on probation for a possession case. I'm not sure how much time she has on that. I know she was on pretrial diversion for 2 years, but I don't know what kind of time she had on the shelf if that got revoked. So I don't think she's any kind of danger to the community. She's got obviously a major drug problem going on here. That she's attempted a couple of rehab places. Evidently, I don't know either one of these places, what their kind of reputation they've got or anything, and I'm not putting them down. I just don't know them. I've not dealt with them before. I think Ms. Parks may be more in need of inpatient, long-term type treatment in a facility where you're there for the 6 to 12 months. You don't come and go as you please. And I don't know if that's what was going on down there, but I think that is what she needs with a possession case for conviction. And now, and then depending on evidently not contacting her probation officer and having at least charges, even though no conviction yet on this new case, again, associated with drugs. I think it's obvious she's in serious need of help. We would ask the court to consider not revoking her at this time, but instead allowing her to be assessed for a treatment program, which I think may be more in tune with what she's needing than what she's had so far, Judge, rather than revoking her to allow her to attempt to do that.
Understood, Ms. Gardner?
Your Honor, I think that there's sufficient proof to show Ms. Parks is unable to be supervised in the community. She failed to complete 2 substance abuse treatment programs. She was given the opportunity to do so very close in time at the beginning of this diversionary period. Obviously, with the pandemic, it's hard to tell what she was doing. I mean, she wasn't drug tested frequently, but that doesn't mean that she was clean this entire time. Additionally, the charges she's facing down in Simpson County, you heard the detective's proof. It sounds like a very strong case. It sounds like Ms. Parks admitted to the conduct. She had a significant amount of drugs on her person and she was selling. I think trafficking in drugs in and of itself is a danger to the community at large. These clearly violate the terms of her diversion, and I'd ask that it be voided.
Well, yeah, the first and the primary issue is whether or not the pretrial diversion it should be voided. And, I believe that it should be. This is, there was already one prior motion to void pretrial diversion that we resolved in lieu of voiding that by having her go to treatment, which she did not complete. She then apparently checked herself into another treatment, before anything else happened and didn't complete that. So, and then went in the wind, for whatever that was, 6 months, 7 months. So at the end of the day, that's certainly demonstrates that you are not complying with pretrial diversion. The question then becomes, I avoid the pretrial diversion, and that imposes the guilty plea, at which point does Ms. Parks want to be sentenced today, or does she want to get a PSI and get sentenced later? Because that's the next step. I'm okay with either one, but I do feel like the testimony is pretty strong that community supervision hadn't been effective. And then certainly, trafficking, 2 new charges of trafficking in methamphetamine and whatever the other controlled substance was. I can't recall, but there were 2 of them. And what that means is that I don't think the Commonwealth has to put on anything additional to make an argument that they've established a danger to the community. That being said, it is her right statutorily to get a PSI before she gets sentenced. And if she wants to do that, that's fine. But for my purposes, I'm granting the motion to avoid pretrial diversion.
Yeah, I would have asked for a PSI on if one's not already been prepared.
Yeah, there hadn't been, because it was, there was a, I'm sure, a post sentencing, I guess is what they call it. But there was probably a questionnaire or whatever, but nobody has seen it. And, all that's part of the right to have a PSI, is that everybody sees, whatever the probation office brings to bear on a sentencing. To answer your first question, Mr. Berry, it's in this case is a year. It was a rocket docket plea, and it was a year. Okay. So that being said, we'll enter an order to avoid pretrial diversion. We'll set it for sentencing. I'd say they're not doing nearly as many of those as they used to. So I can probably set it out about 4 weeks and get a PSI done, or whatever else they need to get done. If there's anybody on here from probation and parole that can tell me different, that, they won't need that long or whatever, that's probably what needs to be done. We'll do what is today, the 9th? We'll do the 8th of March.
All right. Okay.
Yeah.
Is Ms. Parks being held down in Simpson County?
No, she's here.
Okay. I realized she was today. I didn't know if they transported her or if she's going to be just be over here.
No, my understanding is that she might have already gotten arraigned, but that's as far as that case is going. I don't know if that's right or not, but that's what I think I saw.
Okay.
That's
There
right.
hasn't even been an arraignment yet. I don't know, but I don't think it's gone beyond that.
I just need to know where to send her PSI when I get it.
Yeah, I believe she'll be here until we sentence her.
Okay.
That'll be at 10 a.m. All right, thank you.
Judge, I've got a few that are ready.
Can we call Colin Wheat?
What?
Colin Wheat?
That's fine. That's fine.
Yeah. Yeah, I've got it. Just trying to find a place to put all these. All right, Mr. Wheat, you with us?
Yes, sir.
It's my understanding that there has been an agreement reached in your case. Am I right?
Yes, sir.
All right. Can you raise your right hand, please? Do you swear to tell me the truth, so help you God?
Yes, sir.
All right. Thank you, Mr. Wheat. This is your motion to enter a guilty plea. Does that look familiar to you? Can you see
Yes,
that?
sir. Yes, sir.
And on the second page there, it contains what looks like it might be your signature. Is that right?
Yes, sir.
All right. Very good.
10 to probation. Yes, sir.
The Commonwealth's offer sheet is right here. Does that look familiar?
Yes, sir.
And again, on the second page.
Yes, sir.
All right. The third document is the agreed order of pretrial diversion, which appears to be right here. Is that your,
Yes, sir.
on that?
Yes, sir.
Now, did you look at all those and go over them pretty thoroughly before you signed them?
Sir.
Did you have time, if you needed to ask your attorney any questions, to do that?
Yes, sir.
All right. Mr. Wheat, do you feel like today you're under the influence of anything?
No, sir.
Is your judgment impaired for any reason today?
No, sir.
All right. Do you understand that you have the right to remain silent and you waive that if you plead guilty?
Yes, sir.
Do you understand that you have the right to a trial by jury where the Commonwealth has the burden of proving guilt beyond a reasonable doubt?
Yes, sir.
To confront and cross-examine the people that give evidence against you, the right to put evidence on in your own defense, and the right to appeal. You understand those rights?
Yes, sir.
You also understand that if you plead guilty, you waive those rights.
Yes, sir.
All right, thank you, Mr. Wheat. Looking at your offer, the Commonwealth has agreed to make the following recommendations on a plea of guilty to count one, possession of a controlled substance, first degree, first offense. The Commonwealth would recommend a sentence of 2 years. On plea of guilty to count two, possession of synthetic drug, first offense. Commonwealth would recommend a 12-month sentence. Count three, drug paraphernalia. The Commonwealth would recommend a 12-month sentence. And those are the only charges that apply to you. The total recommendation, those sentences running concurrently with one another, would be a 2-year sentence. The Commonwealth would agree to pretrial diversion under supervision of probation and parole office for a period of 2 years, conditioned on you complying with all of the rules and regulations of the probation office and your agreed order of pretrial diversion, which you've told me that you've already looked at and over. In addition to that, you would get a substance abuse assessment, which will be set up for you by probation and parole, and you would need to comply with the recommendations, if any, that come from that assessment. Do you understand all that?
Yes, sir.
Other than what I just told you, has anybody promised you anything to try to get you to plead guilty?
No, sir.
All right. Anybody made any threats to you to try to make you plead guilty?
No, sir.
Mr. Weed, are you telling me that based upon what you and I have just gone over, that you intend to plead guilty today?
Yes, sir.
Do you feel like I'm making you do it?
No, sir.
All right. Are you acknowledging to me?
So that would mean that I would start probation today, correct?
Yes.
And that I would get out. And
Well, it's not probation, it's pretrial diversion, but yes,
that I would be able to get out, and then I would have to report to probation and parole, correct?
that is correct.
All right. Yes, sir.
All right. Are you acknowledging that on March 27th, 2019 in Barron County, you knowingly and unlawfully possessed methamphetamine, synthetic drugs, and drug paraphernalia?
Yes, sir.
All right, Mr. Weed, I'm going to accept your plea of guilty. Today, I'm going to sign your pretrial diversion order. Before we wrap this thing up here, let me ask you, can you give me your the address that you'll be at when you get out?
1255 Park City, Glasgow Road.
All right. 1255.
Glasgow, Park City, Glasgow Road.
Gotcha.
I'll be staying with my grandparents.
Park City, Glasgow Road. And is that a Glasgow mailing address?
I think so, sir. It's right on the
Yeah.
outside of Glasgow. It's
Yeah.
still 42141 area zip code.
Gotcha. Mr. Wheat, I'm signing your agreed order of pretrial diversion. I'm accepting your plea today. We're going to go ahead and get all of this entered. In the meantime, what you need to know is that you will be released from custody, and you are going to need to report to probation and parole. It is probably too late to get anything done with that today. So unless one of these guys that's on here from probation says anything different, you need to report tomorrow by 8:30 a.m. Okay?
Yes, sir.
That's,
Yes, sir.
you know where that office is on Reynolds Road over here?
This right, like going towards Walmart, correct?
Yeah, it's, you know where that Phillips 66, that Travelers Food Mart used to be?
Yeah.
right
Where,
on
the
Valley Road.
gas station?
Yeah, that gas station is right. It's right behind that.
All right, I got you. Where,
Yeah, on Reynolds Road.
Where the newspaper place is.
It's close to that. Yeah. If you can get that far, you're not gonna have any trouble finding it. They got to sign. All right.
Yeah, I got you.
All right. Mr. Brown, is there anything further in this case?
Not for me, Judge.
All right,
Mr.
Mr.
Brown,
Richardson?
can I ask a question?
I don't have anything, Judge.
Are you still gonna be in office after I get released? I'll come see you too.
Probably not today, but I will be tomorrow.
All right, I'll be to see you in the morning then.
That's fine.
All right, thank you.
All right, Mr. Wheat, do what you're supposed to do, okay?
Yes,
Yeah,
sir.
make sure you go to probation and parole before you come to my office, Colin.
All right, I will.
Yeah, they're on here. They know that I've told you to report by 8:30 in the morning, okay?
Yes, sir.
All right.
Make sure you do that.
Thank
Yep,
you.
thank you.
Thank you.
Thank you, Judge. I believe that's all I have.
Okay. Hey, before we go any further, I need to let you all know whoever's doing, what's going to do, I think it might have been Miss Gardner, was going to do Mr. Kearney's case that, you remember when we set this, Mr. Hampton said he had a family court trial.
Right.
You know, he, but they've buzzed up here to the office and said that he's not going to get out of that family court trial.
Okay.
It's gonna, he asked if we would pass it 2 weeks.
I don't have any objection to that. I think Julie and Seth were subpoenaed.
Yeah, I just thought I would tell you so that if you had a witness that wasn't here for anything else, you could identify those people and let them know.
Okay.
After 7, so I'm here for the long haul.
All right, well, everybody's
Judge,
gotta be somewhere.
I think that's all I have, Judge. May I be excused, please?
Yes, sir.
Thank you.
And then I just real briefly I see that Hart County Sheriff's Office is on here. I know that I had some subpoenas on the Horton case. I don't intend on calling any witnesses because he pled guilty in his Hart County cases.
So
That was one of my witnesses too for,
I would also
Okay, I just
point
wanted
out-
to make sure that they weren't hanging around for no reason.
I
well,
would point out, I don't think the Hart County Jail ever got on.
That's what I was thinking too.
Horton's in Barron County, Judge.
No, he's in Hart County, Risa. I called him. I just talked to him.
He
today.
was?
Yeah, he's in Hart
Okay.
County.
Because he was in district court on Thursday afternoon. I thought that for some reason, I thought he was in Barron then.
Yeah, he's in Hart.
Judge, can we call
Okay.
Tanya Pipkin?
Yes.
Well, I guess we'll
Yeah,
just
but-
move that hearing then.
Well, if anybody's listening, they can try to call or get in touch with Hart County and see if they've just forgotten and they want to, join in.
Thanks.
Yeah.
I'll contact them.
All right.
Judge, we got an agreement.
Yeah. Let
We have an
me
agreement in Mr. Pipkin's case.
lay it on me.
Officer Bray tells me that Mr. Pipkin actually has 33 days left on his probation here in Barron County. He still will have time in his Monroe case, and we don't know what's going to happen there. But as far as we're concerned, if he stipulates to violate his probation here, he can serve out as a sanction that is remaining 33 days and will allow his probation to expire.
Yeah. Mr. Bell, are you on here?
I am, Judge.
Are you representing yeah. Is that a done deal or no?
It is, Judge. I guess due to the fact that it's unorthodox, but I guess due to the fact that he has got the pending in Monroe County and it being parallel courts, we would do an Alford plea to stipulating to the violations as put forth by the Commonwealth and do the rest of the time on, as Mr. Richardson said, on his probation.
I think it would be fair to say that he could acknowledge that he has violated a term of his probation without specifying that he committed a felony or another crime or something like that.
Correct, Judge.
If you want to do that.
That's what we'd
That's
like to
fine.
do.
Yeah. Does that work for you, Mr. Pipkin?
Yep. Yes, sir.
What
Yes,
that'll
sir.
mean, yeah, what that'll mean is just you'll do the remaining days, then this case is just over with.
That's 33 days starting today.
That's what
It would,
them to be saying. You would be on probation. Your probation would have expired on
March
March,
11th.
what'd you say, March 11th?
March 11th is what I've been told
Yeah,
by Officer Byrne.
your probation would have expired on March 11th. So rather than revoke you and have you serve, 9 or 10 months or whatever it is, if you just stay in there till your probation's over with as a sanction, then you get out and then your probation's over with. So this case is just put to bed.
Well, you should get out March 12th on these charges here.
Yes, sir.
All right. I can
Thank
live- All right. Thank you, Mr. Pitkin. Good luck, sir.
Thank you, sir.
Judge, can we call Tina South?
Yeah. Hold on just a minute.
Sure.
You don't care. Just so I can.
Mike, I think she's in Hart County. Are they on here?
Nope.
I wish I'd known that.
Bonnie, she's not up there in Barron, is she, Tina South?
No, Greg, she's not.
Okay.
Well,
I think somebody said they were gonna call the Hart Jail and have them get on.
yeah.
Yes. I don't have any idea. If somebody volunteered to call Hart County Jail, tell me, because if not, I will ask my staff to do it. I guess I'll be asking my staff.
I don't know who offered, but I just sent them the email, so I will go and call.
I mean, they've got the email. I mean, we've sent it to them twice.
Never mind.
Yeah, all I can think of is that they just, somebody just forgot or, whoever you sent it to is not working today or whatever, It did.
Sir, I did talk to him. This is Deputy Nichols. I just got on the phone with him. And I guess they forgot or whatever, but they had somebody send the link and they would get him on ASAP.
Super, thank you.
Well, Judge, if we're waiting on them, can I just go ahead and call another case?
Oh, well, sure.
I was going to call Brittany Decker. We were going to have a hearing on that. I've got Officer Garner with probation and parole as my only witness.
All right, thank you. All right, who did you say you were calling, Mike?
Officer Garner.
Oh, okay, there he is. All right. Sir, can you raise your right hand for me, please? Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth? So help you God.
I do, sir.
All right, thank you. Go ahead, Mr. Richardson.
Can you state your name for the record?
It's Officer Jeremy Garner.
You're with probation and parole.
Yes, sir.
Did you file a violation report on a Brittany Decker dated January the 4th of 2021?
I did.
Can you tell the court what the basis for the violation report was?
On 12/9/20, Ms. Decker appeared for intake at the Columbia Office of Probation and Parole, and she had admitted to using methamphetamine and drinking alcohol the night before she reported to me. Instead of incarcerating her in lieu of asking for the court for revocation, I referred her to the social service clinician and gave her a report date of 12/15. The SSC made 3 attempts to contact her. Before she had left that day on 12/9, she was explicitly instructed to make sure she abides by the SSC's recommendations and contact, and elaborated on the importance of cooperating with the social service clinician. And she stated that she understood. After 3 attempts of no contact and me not being able to get a hold of her, I started to trace her down to find out where she was, and I couldn't get a hold of her either. I made contact with her employer, her alleged employer, who stated that she only worked a few days before quitting during the training process, and no contact has been made since.
Okay. Did she also fail to to go to her substance abuse evaluation?
Yes, the SSC, like I said, made 3 attempts to get a hold of her and never could get a hold of her.
Okay. That's all the questions I had, Judge.
All right. Is this Mr. Spears' case?
Yes, it is, Your Honor.
All right. Got any questions?
Yes, Officer Gardner, you also put in the supervision report, something about, that her case got transferred to another office. What office was was her case transferred to?
She was the transfer was for me for her to transfer from where she was coming from to Cumberland County, where I'm the probation officer for that county. And I was going to accept it upon intake. And when she failed to abide by the intake, she got reverted back to the Glasgow office under Officer Alexander.
Okay. Where was she supposed to meet was she supposed to meet the SSC in your office in Columbia, or where was she supposed to meet the SSC?
Due to the COVID-19 protocols, the SSC is calling and doing all her stuff via phone and via Zoom. And the phone number that I acquired from Ms. Decker during the intake process was forwarded onto Jamie Brumley, our social service clinician, and was added to her schedule.
Okay. Your Honor, I have no further questions of this witness.
All right, Mr. Richardson, do you have any redirect?
No, sir.
All right. Do you have any additional proof?
That's it, Judge.
All right. Do you need Officer Garner to stay with us, or is he free to go?
I don't need him, Judge.
All right. If this is the only case you have, sir, you're free to go. You're free to stay too, but you're free to go. All right. Mr. Spears, do you have any proof that you are putting on?
Yes, I call Ms. Decker.
All right. Ms. Decker, can you raise your right hand, please? Are you with me?
Yeah, I'm right here.
All right. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Your witness.
All right, Ms. Decker, you heard the testimony of Officer Gardner. Can you explain to the court what was going on with the not reporting to the SSC or not being able to get in contact with the SSC?
Well, first of all, I called him after that situation, and me and him talked on the phone while I was at my workplace for, well, about an hour about this whole situation, but it was after he done put out the warrant. But I mean, I'm just telling you, I did finally get in touch with him. But with the SSC situation, I told him the day that I come in there and reported and admitted to using. He didn't violate me, but he told me I did need to make sure I was able to answer the phone call for that social worker lady, whoever. And where I was living at in Burkesville, I'm literally had just moved there. Like, I've been there a week, and my phone is completely dead, completely in that whole area, Marrowbone, wherever that was. And it had no service at all. Like, I had to walk down the road sometimes to pick up a little bit of signal. And I told him this, and he said, well, just make sure you're somewhere where you can signal. I tried my best. I mean, I really did. I tried. And then afterwards, I got a hold of him. And then I had to leave Marrowbone and go back to Hart County, which I contacted him, let him know that I was coming back to Hart County, or to out of that area anyway. And I also tried to contact Jason. I left him a message, Jason Alexander, but Jeremy Gardner, he told me that it was too late, that he done put out the warrant because that lady could not get a hold of me. And he told me how easy it would have been just to let him know that I was leaving again, and that, but I mean, I did try. I contacted him as much as I could, and this all happened within like a week, 2 weeks. And I mean.
All right. Would you be willing, if you were to get evaluated by the SSC or through us, would you be willing to go to whatever treatment is recommended?
I would actually. I think I need treatment. I've never been before, and that's something I was really, serious about. this time we
Okay.
did pick up.
All right. No further questions, Your Honor.
right.
I got accepted into a treatment program.
Oh, yeah, that's right.
Yeah, I got accepted into one. They actually are supposed to be faxing the papers over here to the jail, but there's a problem with the fax machine. I think it's the Freedom House in Bowling Green. They got a bed for me today.
Okay. That's all I have, Your Honor.
All right, Mr. Richardson.
I don't have any questions, Judge.
All right, very good. Mr. Spears, what's your argument here?
Judge, as Ms. Decker just pointed out at the end of her testimony, she has she appears to have a bed at the Freedom House in Bowling Green. I think in this situation, I realize this is the second revocation hearing we've had on her since she signed her pretrial diversion in 2018. However, I think that I believe that, given the circumstances, that she should be given another chance, allow her and be allowed to go to the bed at the Freedom House. I'd ask in lieu of revocation that she stay on diversion with the added stipulation that she go and complete all the necessary programs and complete the Freedom House.
Mr. Richardson.
It's actually the third revocation hearing. She had two prior ones in October 2019 and then back in August of 2020. And really, it should be the fourth. We chose not to file something a couple of months ago when the Officer Garner wasn't asking for revocation. They tried to work with her. Problem here, Judge, I think it's all too little too late for her. She's completely unsupervisable. In that report that I submitted to the court that Mr. Spears also has a copy of, I mean, it's long. She's had a long list of violations. She's had multiple chances to attend treatment, to be assessed. She never makes herself available. She pretty much picks and chooses when she makes herself available to probation and parole. I just think it's time this is pretrial diversion. We've tried to do sanctions. The first time it was a 60-day sanction. The next time it was a 90-day sanction. And I think at this point, she's had more than enough opportunities to be supervised, and she refuses to do so. So I'd ask for her pretrial diversion to be voided and for her to go serve her time.
Well, this is a case that during the period of time that she's been on pretrial diversion, she's got either 2 or 3 new felony cases. I think there was a felony charge in Berrien County that got amended, never got indicted, got amended down to a misdemeanor, which is another one. It's just been, this is certainly a case, regardless of how you think about what you're going to do on a long-term basis, sentencing wise. This is clearly a case where, the pretrial diversion should be voided. I mean, I want, she's been indicted, I think, in at least 2 other counties or 2 other cases. And so, she ain't going to get a pretrial diversion in those cases anyway. I don't know what'll happen in them, but Mr. Richardson is correct. This is the third hearing that we've had in addition to new arrest. I mean, absconding is an issue here. It's been an issue before. For whatever reason, it does not appear that supervision in the community has been workable for Ms. Decker. So the answer to that question is the motion to void pretrial diversion is granted. Now the question is, do you want me to go? We can put her on for sentencing in 4 weeks like I did in that previous case, and we can figure out whether or not, what we're going to do going forward, probation or pretrial or probation or serve the sentence. But I don't think that there's any way to stay on pretrial diversion under the circumstances of this case. All right.
That's now, sir. Sorry.
I'm sorry.
Do I have to wait the 4 weeks to get sentenced, or can I just get that done today?
Well, that is up to you and your attorney, because you have the right to have a separate sentencing. But if you want to waive that, you might talk. I don't know. You may want to talk to him first. I don't know.
Can you call the jail? Can you call the jail?
I'll just tell you, I'd recommend waiting because we have to have a PSI in order to probate, in order to ask for probation, so.
Okay, but how long is my probation, my pretrial diversion supposed to?
Okay, we'll just, Judge, can we put this off like till Monday possibly so I can go talk to her? I know we want a PSI ready by Monday, but we choose to.
Yeah, I mean, I can just say we're going to review it Monday on the 10 o'clock docket if you want me to.
Yeah, I think that'll be the best option because that way I can go speak to her some more now that the diversion's been voided.
All right, very good. That's what we'll do. Thank you.
Your Honor, we'll call Robert Fields.
Yes.
He's on here. I've spoken with his probation officer, and we're going to withdraw this motion at this time. Or actually, I spoke to the deputy. He had an offense back in September. He's on misdemeanor probation. He's got a new felony pending. We'll just handle that, and when it comes through.
Okay, so he's going to stay, basically you're withdrawing your motion. He'll stay on probation in this case.
Misdemeanor probation in this case, yeah.
Right,
unsupervised.
All right, Mr. Fields, you got that?
Yes.
Okay. Hey, let me ask you a question while I got you on here, just in case it might help you down the road if something else comes down the pipeline. Do you have a different address than where you were when all this started?
No, but I haven't been getting the mail and stuff right. I don't think they've been putting the apartment on there.
Well, tell me your address again.
Okay, it's 110C, apartment C, North Franklin, Glasgow. Yeah.
All right. So are you saying it's 110C or just 10C?
110.
Gotcha. All right. That ought to do it.
All right. Thank you, guys.
All right. You bet.
And also call Pamela Morris. We have an agreement reached.
Yeah, I need to have 30 seconds, no more than 30 seconds. Just bear with me.
Right. I'll leave this thing.
Hey, Greg.
Yeah.
I guess since Hart County is on, when we take up them, if you could ask Tina South about what we talked about.
I will. Yeah, I will as soon as, I don't know if she's on there now.
She's not, but just whenever she comes up.
Okay.
Who had Brittany Decker's case? Was that Mike's case?
Yeah, that was mine.
So did he void the pretrial diversion and he's just going to set it for review on Monday?
Right. They're just trying to decide whether or not she wants to be sentenced or not.
Yes, sir. Thank you.
Okay.
Ken, you actually put your name on there this time.
I did. I updated my Zoom profile.
More than 30 seconds. All right. Let's change his address so that next time around, if you send him something.
Yes, sir.
Let's make sure that's his address. I don't know, whatever the deal is. Hey, what'd you say, Pamela Morris?
Yes, Judge.
Yes, Your Honor.
Yeah. All right. Looks like somewhere along the way, a motion to enter a guilty plea has appeared in this file.
Yeah, we reached an agreement on this, Your Honor. I think we need to clarify a little bit of the language on there.
Yeah.
It says 20-day alternative sentence on that. That 20-day is from when she went into custody this past time.
All right. Is that?
Which I think it's January of 26th, is that, or something around there?
Mr. Garrett, is that what you all are?
Yes, that's the substance of the agreement, Judge. I don't know the exact date, but yes, that's correct.
Yeah, I'm going to tell you the date in just a minute. As soon as I can get my fingers to work. 25 January.
Yes,
So roughly,
6 days left.
yeah, roughly 14, 15 days ago, something like that. Okay,
Yes, sir.
Ms. Morris, you ready to go?
Yes, sir. Yes, Your Honor.
All right. Can you raise your right hand? Do you swear or affirm that you will tell me the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Ms. Morris, let's start with this document. Wait, I'm gonna get you on here big here. All right, let's start with this. This is called a motion to enter a guilty plea.
Yes, sir.
Can you see that?
Yes, I can.
All right. And on the back page is a signature page. Is that your signature?
Yes, sir.
Thank you. The Commonwealth's offer is right here. This is the front page. Okay?
Yes,
Is
sir.
that familiar?
Yes, sir.
This is the second page
Yes, sir.
that have your signature on it.
Yes, sir.
Very good. Did you go over both of these two documents before you signed them?
Yes, sir.
Did you understand what they say and what they mean when you signed them?
Yes, sir.
All right. Did you have ample time to discuss them with your attorney?
Yes, sir.
All right. Ms. Morris, do you feel like you're being forced by myself or anyone else to enter a guilty plea today?
No, sir.
Thank you. Do you feel like you're under the influence of anything right now?
No, sir.
Is your judgment impaired for any reason today?
No, sir.
Ms. Morris, do you understand that you have the following rights which are waived if you plead guilty? You have the right not to incriminate yourself. You have the right to a jury trial where the Commonwealth has the burden to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine witnesses. You have the right to put evidence on in your own defense. You have the right to appeal.
Yes, sir.
Okay. Do you have any questions about what it means to waive those rights?
No, sir.
All right. In this case, the Commonwealth has agreed to make the following recommendations upon your plea of guilty. Count 1, wanton endangerment in the first degree, which is a Class D felony. The Commonwealth would agree to recommend a sentence of 3 years plus a fine of $1,000 and court costs. Count 2, criminal mischief in the first degree, a Class D felony. The Commonwealth would agree to recommend a sentence of 3 years. Count 3, driving under the influence of alcohol or any other intoxicating substance. Third offense, the Commonwealth agrees to recommend a sentence of 12 months plus a fine, a DUI service fee, DUI counseling, and a license suspension as dictated by statute and administered by the Department of Transportation. Count 4 and count 5 are criminal mischief in the third degree. Commonwealth agrees to recommend 90 days on each one of those. Count 6 is failure to maintain insurance. Commonwealth agrees to recommend a 90-day sentence on that. All of these sentences would run concurrently with one another. The total recommended sentence would be 3 years, plus the possibility of fines, plus the DUI service fee and other DUI sanctions as referenced above. There would also be restitution to the tune of $2,033.79. The Commonwealth would agree to probate that sentence for a period of 3 years, or if restitution has not been completed within that time, your probation would last until your restitution got paid. This would be subject to a 20-day alternative sentence with the 20 days beginning January 25th, 2021, which, as we mentioned, was roughly 2 weeks ago. You would also, as a condition of your probation, get an assessment for substance abuse. And if there was any recommendation regarding treatment, that would become part of your probation. Do you understand that that is what the Commonwealth is offering to do in this case?
Yes, sir.
And by signing that offer, it appears to me that you have accepted that offer and plan to enter a guilty plea accordingly. Is that correct?
Yes, Your Honor.
All right. Have you been promised anything or threatened with anything other than the Commonwealth's promise to make those recommendations?
No.
All right. Ms. Morris, are you acknowledging, well, let me ask you this. Do you feel like you're being forced into this by me?
No, sir.
All right. All right. Are you acknowledging today freely, voluntarily, that on August 30th, 2019 in Barron County, you committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, you wantonly engaged in conduct creating a substantial danger of death or serious physical injury to another person?
What am I supposed to say? Guilty?
Yeah, I'm asking if you're acknowledging that, if you're admitting that, if you're pleading guilty, you say yes. If you don't want to plead guilty, you say no.
Yes.
Okay. Are you also acknowledging that you are admitting that you committed the offense of criminal mischief in the first degree when you had no right to do so, nor any reasonable grounds to believe you had the right to do so, but you intentionally or wantonly damaged or destroyed property belonging to another person, causing a loss, monetary loss of $1,000 or more?
Yes.
All right. Are you acknowledging that you were operating a motor vehicle on August 30th, 2019 in Barron County under the influence of a substance or combination thereof that impairs your ability to drive, having 2 prior convictions within the immediately preceding 10-year period?
Yes.
All right. Are you acknowledging that at the same time and place, you were also operating that motor vehicle without the insurance on it as required by law?
Yes.
Okay. And are you acknowledging that at the same time and place, you committed 2 counts of criminal mischief in the 3rd degree when you intentionally or wantonly damaged property belonging to 2 other people, namely a building and a PVC pipe, which would have both been a loss under $500?
Yes.
All right. Then I am going to, Ms. Morris, accept your guilty plea here today. Mr. Garrett, are you all anticipating, I assume you are, that she's sentenced here today?
If we can, Judge, yes.
Yeah. All right, Ms. Morris, I'm gonna go ahead and sentence you to a 3-year sentence on count 1, 3 years on count 2 to run concurrently for a total of 3. The DUI sanctions will also be imposed. The other sentences, 90 days and 12 months, will all be concurrent. The total sentence will be 3 years. I'm going to grant your request for probation after service of a 20-day alternative sentence beginning January 25th, 2021. That means that you will be getting released. It seems like the way those days are falling that you'll probably get released on a weekend. So you'll need to report, the first business day to probation and parole by 8:30.
Okay. Do I know who's going to be my probation officer?
I don't know that yet. They'll have to assign that to you. They have some
Walk
internal.
in the door and they'll tell me when I walk in. Is that how it works?
They have some, internal algorithm that I don't know how they do it, but
Okay.
it's probably really complicated, but they'll figure out who it is by the time you get there. Okay.
All right. Thank
All
you,
right.
Judge.
Let me remind you
Mhm.
that in addition to all of this, you got these DUI sanctions. You're going to have to sign up for DUI counseling. Your driver's license is going to be suspended.
I know.
You're going to have a lot going on.
I got to sign up for DUI counseling.
Huh?
I have to sign
Yeah.
up for DUI counseling. Okay.
Yeah, that's automatic, you know, regardless of whether you're on supervised probation and you know, whether you do some kind of outpatient treatment through probation and parole or whatever, you still got to do that DUI counseling.
Okay.
You got a service fee, which is $425. You got court costs, which is usually $165. So it's probably in that ballpark. I'm going to give you 12 months to get all of that paid just because it's, you know, it's not insignificant. You have fines, which are $500 for a DUI and $1,000 for a felony. So that's $1,500. But I'm going to suspend or probate that just, you know, so that you can try to get all this other stuff taken care of because you're going to have to pay for it too.
All right, thank you.
All right. So if something were to happen and you weren't able to pay that, I mean, something were to happen and you get in trouble and, you know, we come back here to revoke your probation or whatever, you know, one thing that could happen is I could order you to pay that $1,500. Okay.
Okay. So you're gonna, what did you say? You're gonna suspend them, the what? What were the last two you said?
Yeah, I said I'm going to suspend the $1,000 fine on your felony and the $500 on your DUI. You still owe the service fee and the court costs, which adds up to, you know, something like $600. All right.
All right. Thank you, Your Honor.
All right. Thank you.
Thank you.
Good luck, Pam.
Thank you. Thank you.
Judge, can we call Tina out? I'm sorry, Reese.
I was gonna try to get Childress out because he's been sitting in his car, if that's okay. On Eric Denton.
Tina South should take a second. I've had Deputy Nichols waiting for quite a while. You can give me 2 seconds.
Okay.
Ms. South, are you on there?
Yeah, you got Tina South. They changed.
She's back there.
They changed.
Still, yeah, she's Hart County, so.
She's in Hart County.
Exactly.
Yeah.
All right, you want to talk to her?
All right. Hold. Okay, that's Miss South right there. Okay. What are we doing, Mr. Richardson?
Well, Greg, you want to tell her what we're doing? Ask her if she wants to do.
Yeah, I'll ask. I don't have Hart County on here, so that was what I wasn't saying anything. Ms. South, you hear me okay?
Yes, sir.
Okay. They're offering on this revocation to just recommend a 60-day sanction rather than revoking you and give you credit for the time you've already served.
Okay.
When did you start serving on it?
December the 23rd.
Okay. So you're closing in on the 60 days here pretty quick.
Yes, sir.
You want to accept that?
Yes, sir.
Okay. That's it, Judge.
All right. So you went, I'm just trying to track that down. You went into custody on December 23rd.
Yes, sir.
All right. Fair enough. A lot of times that's hard for us to determine.
She's also serving a sanction in Hart County, I believe, too, Judge.
Gotcha. All right. Miss South, we'll put you down there for a 60-day sanction in lieu of revocation. It'll date back to December 23rd. And of course, this here is February 9th. So it looks like you may have something like a couple weeks left on that, and then you'll be getting back out. You need to report to probation and parole when that happens. Okay.
All right. Thank you, Your Honor.
All right. Thank you.
Judge, can we release Deputy Nichols?
Yes. Thank you.
Do I need to be here for Robert Dale Horton? No?
No.
Okay.
Thank you, though.
All right. Miss Gardner, who were you calling?
I was gonna call Eric Denton to motion to revoke bond. I have Officer Childress.
All right. Officer, oh, there you are, Officer Childress. You're on mute right now, so if you'll unmute, I'll swear you in.
There we go.
All right. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right. Thank you. Go ahead, Ms. Carter.
Thank you, Judge. Could you please state your name for the record?
Jeffrey Childress.
And you are with the Cave City Police Department?
Yes, ma'am.
On January 14th of this year, did you arrest Eric Denton?
I did.
Could you please tell the court where you found Mr. Denton and what you ultimately charged him with?
Yeah, me and Officer Fletcher, we were dispatched to a suspicious car out at Dairy Queen in the parking lot. We get there, passed out behind the wheel with the car running in their parking lot. We knocked on the window a couple of times, tried to get his attention. He finally come to. He was very slow to respond. His speech was incoherent. Officer Fletcher noticed he had a pretty large lump in his sock. So we get him out of the car. He pulls out a cigarette pack that has a glass pipe and a wad of cash in his hand, and a pill bottle down in his sock that had, I believe it was 9 gabapentin in it. And then upon search of the car, there was digital scales located in the floorboard. There was a bag of suspected methamphetamine and a black cloth bag located on the center console. So with everything combined all together, he was charged with trafficking of methamphetamine, DUI, second aggravated offense, possession of the first degree second offense for the pipe and I believe there was enough suspected methamphetamine down in the pipe to charge possession. That's why he was charged with possession as well. Drug paraphernalia by and possess, and then possession of controlled substance third for the gabapentin.
Did Mr. Denton make any statements to you about the meth that was found in his car?
He said the baggie of methamphetamine that was found in the center console in that black cloth bag, he said that wasn't his.
Okay. And did he submit to any test of his blood or breath or for the DUI?
He submitted to field sobriety when we were out there, but when we got to the hospital, he refused the blood draw.
Did he make any admissions to using
That's why
methamphetamine or
I
any other drugs? I'm sorry, could you repeat that?
No.
He did not?
That's why I
Okay.
charged him with the aggravated. Yeah.
Okay.
But no, he didn't make any statements as far as him using anything like that.
Based on your training and experience, he appeared manifestly under the influence to you. Would that be fair?
Definitely. Just the way he responded and then all the clues he gave us on the field sobriety test as well.
Okay. I have no other questions, Judge.
All right, Mr. Spears, is this you?
Yes, Your Honor. Officer Childress, you say you only found one baggie of meth, is that correct?
That's correct. It was in the center console.
Okay, was this vehicle Mr. Denton's vehicle, or was he driving someone else's vehicle, or do you know who the owner of the vehicle was?
I believe he said it was his father's vehicle.
Okay. And he was the only person in the vehicle, is that correct?
That's correct.
Okay. Has
He actually made a statement to me at first. I'm sorry, go ahead.
No, you go ahead and finish what you're saying.
He had made a statement saying that him and his brother were traveling from Glasgow and they were trying to get to, I don't remember if he said Arizona or Arkansas, but somehow he had made it to Cave City and said he had pulled in there because he got tired.
Okay. Has the suspected methamphetamine, has it been tested or is it still pending at the lab?
I'm not for sure. I would say probably still pending.
Okay. No further questions, Your Honor.
Ms. Gardner, redirect?
No, Your Honor.
All right. Any additional proof?
No, Judge.
Is Officer Childers free to go if he wants to?
Yes.
All right, any proof from the defendant?
Judge, I've advised my client against testifying at the current time due to the pending charges. I do have an argument, however.
All right, hit me.
Your Honor, I mean, I use this argument a lot, but you know, I think in this situation, we have an innocent until proven guilty situation. I think there's a lot more that needs to be fleshed out in this case before determining whether Mr. Denton is guilty of the charges he's being charged with, specific, especially the trafficking charge in and of itself. The issue I have is I'm well aware that, you know, a new arrest is a violation of bond conditions. I believe that Mr. Denton should be given a sanction in lieu of revocation and be given another chance out on the street, possibly with stricter supervision at the discretion of the court. So I just ask in lieu of revocation, he be given a sanction, placed back on bond with potentially stricter supervision, but be allowed to be back out on bond to take care of his work duties and his duties with his family.
All right, Ms. Gardner, anything that you would like to say in response?
Your Honor, this is the second time I think we've been here, at least on the 2019 case, to revoke Mr. Denton's bond. He has 2 pending cases in Barron Circuit Court right now. Both are drug related, involving methamphetamine. In this case, he was found, he was called in as a driver under the influence. Someone passed out or acting funny in the Dairy Queen parking lot. Officer Childress testified that based on his training and experience that Mr. Denton was obviously under the influence of something, which in and of itself is a violation of his probation. Additionally, there is a significant amount of meth for him to be charged with a Class C felony in addition to scales and cash. While he is innocent until proven guilty, he was found to be in possession of meth and he was found to be under the influence and he was charged with those crimes. So he has new charges, which is obviously a violation of bond conditions, as well as it appears that he consumed intoxicating substances to impair, to the point that he was impaired. So I think there's enough to revoke his bond at this time, Judge.
I'd like to speak, Judge, if you don't care. If I got to go on an oath, that's perfectly fine.
Well, your attorney has.
That's perfectly fine. I'd like to speak on it, even if I got to go on an oath. That's cool.
So you understand that your attorney is advising you against it and you have.
Absolutely, 100% understand.
All right. So if you do say something, it might be held against you in another case.
All righty.
All right. Raise your right hand. Do you swear to tell me the truth, the whole truth, but the truth, so help you God?
Yes, sir.
All right. I'm going to let your attorney question you. So go ahead, Mr. Spears.
All right. Mr. Denton, explain to the court what, about what's going on with this situation.
Well, Ms. Gardner said this is the second time we've been here. I'm pretty sure this is the first time we've been here. While I was out on the streets, I've reported for all 4 months. Judge, I had a job. I was making child support payments. I got my license back. I've never had the ankle monitor or any type of U-turn, anything like that. So if I could get reinstated on bond and do U-turn or anything like that, I'd be willing to do that. Definitely innocent until proven guilty. I've been fighting one of these cases for 19 months. Been fighting another case for 13 months now and haven't been proven guilty on none of them. So, I mean, the state can't really have a very strong case against me if it's been over 2 years combined on these cases. That's all I got to say. Thank you for the time. Because last time I was in court and got to the topic, they just cut me off. So I appreciate Judge Alexander. Thank you very much.
All right, sir. Mr. Spears, do you want to ask him anything else?
No further questions.
Ms. Gardner, do you want to ask him anything?
Sure, Judge. Mr. Denton, you were found with a glass pipe in your sock, correct?
Yeah, I'm going to object to that because it's getting into beyond the scope of what he was discussing.
Yeah, we're just here
I don't think
on the bond.
That's
right?
not beyond the scope of direct. Isn't a.
We're just here for reinstatement of bond, right, Judge?
Do what?
We're just here on the revocation on my bond, right? We're not discussing any other cases. We're just.
Well, they're asking to revoke your bond because of your new arrest on January 14th, where the officer just testified that he found you with a meth pipe in your sock. So that's why she's asking you.
Right, which is all allegedly, because I'm not guilty on any of those, so.
Well, I mean, it's allegedly from the standpoint of whether you're guilty or not, but it's
Right, absolutely.
from the standpoint of whether he told me that because he just told me. Right?
I mean, I'm not agreeing to anything that the officer just testified. No, sir.
I'm not expecting you to. I'm just saying he didn't allegedly tell me that. He told me that.
Yeah, that's what he said. Absolutely.
Right. Sure. So
can I ask my question, Judge?
The question from Ms. Gardner is, did Officer Childers find you with a meth pipe in your sock?
No.
Okay.
There is no one else in the vehicle with you, correct?
I was by myself.
And this vehicle was your father's?
That I was
Registered to your father?
That I was driving.
Okay. So you had no glass pipe in your sock?
Nope.
Okay. And you didn't have any gabapentin on you either?
Nope.
And you didn't have any methamphetamine in the car? Okay. All right. I have no further questions,
And
Judge.
it even says on my citation that I was 5 out of 5 on the first identifiers of the field sobriety test, and 5 out of 8 on the other one, and then failed the last one.
Those are what you missed. Those are the things you missed.
All right, Ms. Gardner, is that it for questions?
That is.
All right, Mr. Spears, redirect?
No redirect, Your Honor. My argument stays the same.
Understand.
As Mr. Denton pointed out, the stricter restrictions that I was pointing out included potential ankle monitor. Then, yeah, my argument stays the same.
I understand. All right.
Judge Alexander, I wasn't absconding or anything like that. I reported all 4 months on probation. So, I mean, it wasn't like I was hiding or running or anything like that.
I understand. Ms. Gardner, do you have a statement that you want to make?
No, Your Honor. I mean, these things were found. I think that Officer Childress has probably better things to do than frame someone in Dairy Queen parking lot with a meth pipe and methamphetamine in someone's car. He's currently charged with methamphetamine offenses. He is innocent until proven guilty, but I think the evidence in this case is strong that he has violated the conditions of his bond and it should be revoked.
Yeah, I mean, here's the thing, and I, just to make this, I mean, not that it's all that relevant, but I mean, if you're a 6, I mean, I've heard a million officers testify about field sobriety tests and DUIs. You can't be a district judge, for almost 10 years, and you try, 2 or 3 of those a month. They're looking for 6 clues, and you showed them 6 clues. Is what he meant. So, I mean, I don't know whether you're ultimately going to be guilty of that underlying set of new charges or not, but that's not the question. And, I do appreciate, I mean, I've been in that situation having to make that argument. I do appreciate that when your client is out on a trafficking charge and he gets arrested and charged with trafficking, one of the only arguments you can really make is, well, he hadn't been found guilty of that trafficking. He's innocent until proven guilty. And that's true, but that's not the standard for a bond violation. It's, is there proof, even if you say, is there a preponderance of the evidence that he violated his bond? I mean, the officer testified. I find the testimony to be credible, at least to the point that Mr. Denton said he did not find any pipe, gabapentin, or methamphetamine in the car, and the officer testified that he found all 3 of those items in the car. And whether they were yours, what legally possessed them, whatever the case may be, at the end of the day, I believe that the officer found those items in the car, for what that's worth. So, the question becomes, is there, enough there for there to be a violation of bond? We do this, 20 times every other Tuesday, you're out on a charge, particularly if you pick up the same charge while you're out on bond. I mean, the chances that I feel like, and I think most judges agree with me, that there should be a revocation of bond in that situation it's almost always going to happen. All right. That doesn't mean that you're never going to get a bond. That doesn't mean that, you're going to jail for the rest of your life. It doesn't mean any of those things. It means, did you violate your bond? And I think the answer to that is yes. And therefore the appropriate thing to do is to, at least for the time being, grant the motion that the Commonwealth has filed. We can always revisit it, later at a pretrial conference or something else. But right now, I'm granting the motion, and we'll set a pretrial conference. We loaded up the first Monday or Tuesday of March, so I'm putting this one on March 15th
Okay.
at 1 o'clock.
I got a case that's 19 months old, and none of that's been proven from the lab that it was meth or anything. So how can we just say that anything that was found in the car was enough? I mean, I've had one chance on this bond, and was working and everything. It wasn't like I was just being a menace to society. I've had one chance. I can't get a second chance to reinstate it or get out on an ankle monitor or something.
I didn't say I was never going to reinstate your bond. But this is a question about whether it's going to be revoked based on the Commonwealth's motion. And I don't see that there's a whole lot of choice. I mean, they put the proof on and it's there. I don't know about.
We can't do the ankle monitor.
Well, I mean, we might be able to do that at some point, but we're not going to do it right now.
All right.
Judge,
All right.
Judge, one thing I wanted to bring to your attention is that I did file this motion, and it is titled in 20 CR 178
right.
and in the 19
right.
case. But
somehow
I did not.
It didn't get it. Yes, somehow
Okay.
It didn't get in there, but
I just wanted to make sure.
they gave me both files, and I'll enter the order in both.
Okay, thank you.
Locked up for a month, Judge. I just don't understand why we can't do the ankle monitor right now. I was living with my mom where I paroled out to. Why can't I go back to my mother's house and I'd be on ankle monitor and you know exactly where I am? I didn't skip any court dates or anything like that.
Listen, Mr.
I
Dent,
allegedly caught new charges.
I know. I've already told you what we're going to do for now. Okay.
But you don't understand, or you don't care to acknowledge what I'm saying. Like, what would be wrong with ankle monitor? I've seen people that's got in here with guns and.
No, I'm going to tell you what I don't. What I don't have to do is explain it to you over and over again.
We've only said it once, sir.
Well, then if I say it again, it'll be over again.
Like I had a child support, like I was making payments, working, I was being productive. It wasn't like I was being a menace to society. I don't understand why I can't get a second chance.
All right. I didn't say you weren't going to get a second chance. I said you're
going to be right now.
Today.
So I'm on no bond till the 15th.
That is correct.
All right.
Judge, can we call Paul Gass?
Hey, Bonnie, you might want to tell Mr. Denton if he ever wants to get a chance for a bond, he'll quit griping.
It wasn't Denton acting a fool.
What?
That's not what I go about.
You got Mr. Gass.
Yes, so you got pressure.
Judge, I've just got one witness, Miss Atkins.
Yes, sir, Your Honor.
Didn't shut it.
Or what? Or what, buddy? I don't do.
We ready?
Yes, sir, Your Honor.
you calling Miss Atkins, you said?
Yes, sir.
All right. Miss Atkins, do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God? Oh, you're muted.
Yes, sir, I do.
All right, there we go. All right.
All right. Can you state your name for the record?
Julie Atkins.
And you work for the U-Turn office?
I do.
And were you monitoring a Paul Gass in his case, 20 CR 230?
I have been. We've been supervising Mr. Gass, his bond since January 23rd, 2020.
Okay. Did you file a violation report on January the 12th of this year?
We did. I'm sorry.
What was the basis of it?
We called Mr. Gass in for a test on January 12th. Field test results were positive for methamphetamine and amphetamine use.
That's all the questions I had, Judge.
So you've been supervising or monitoring him for over a year now?
Right at a year, yes, sir.
And is this the only positive test he's had during that time?
No, sir. He's had, we filed, I think this is the 4th violation that we filed for Mr. Gass. And of course, there was a period of time when we were not testing because of COVID.
Yeah. That's all the questions I've got, Judge.
Mr. Richardson.
I don't have anything else, Judge.
Okay. Mr. Berry, do you have any proof you want to put on?
No, not at this point, Judge.
All right.
I would like to make a statement.
Okay. Yeah, go ahead.
Yeah. His violation here is the positive test on 1/12/21. We'd ask the court to sanction him for that rather than revoking his bond on it. I'm not sure when Paul went to jail on this, if it was that day or after that, but so I don't know how much time he's been in jail for this. I'd ask the court to not revoke his bond on this, but to sanction him for it and to keep him on the supervision with Ms. Atkins.
Okay, Mr. Richardson.
Judge, Mr. Gass, he's obviously violated his bond conditions. He has a long history of drug use, and I've made offers in this case. I don't know if we made much headway because he's not, I don't know if he's met with Mr. Berry or not, and he's using drugs, and he's got a long history of drug use dating back several years. I think it's best to revoke his bond so we can try to resolve this case.
Well, listen, Ms. Atkins had been monitoring you, Mr. Gass, for quite some time. The reason that we haven't had any hearings in this case is twofold. Number one, I think 3 times in district court before you got indicted, you got warrants for bond violations. And then when you got indicted, you got a bond violation and you got a warrant for that. So, you got put into custody until I could arraign you. So really, this is the 5th time that there's been a problem during that stretch. Several of those months of which there weren't even testing being done. So, here's the thing. I agree that, you didn't get a new arrest or anything like that. But I mean, this has been a persistent problem. And in the meantime, we can't get any headway or get anything accomplished. So what I'm going to do is for the time being, at least, make a finding that, that positive drug test is a violation of bond. I'm going to grant the Commonwealth's motion. And then what we'll do is put this on for a pretrial conference. Mr. Berry, I mean, if you think there's a chance you all can discuss things in a couple of weeks, I'll put it on for 2 weeks. If you think that's feasible.
It is. That's what I'd like, is the first one available.
Yeah, I'll put it on February 22nd at 1 o'clock.
Okay.
Yeah. All right. Thank you. We ready to do Mr. Horton?
I am judge.
All right. Thank you.
Honor, I was not going to call any witnesses. The basis for this revocation are 2 new misdemeanor arrests in Hart County. One was 20 M416, which was assault, fourth, domestic violence, and a violation of an EPO. He pled guilty to that already. And then there was also 21 M9. That was just a violation of an EPO, and he pled guilty to that as well. He does have pending another Barron County case that has been amended up to a felony because it's his third assault, fourth, domestic violence within 5 years. So I basically would like to make argument. I've attached those cases or the citations, I think, to my motion.
Yes, ma'am. Which attorney's got this one?
This is mine, Your Honor.
All right. So Ms. Gardner is just asking me to take judicial notice of official court records.
That's correct.
Which I can do, unless there's any dispute about whether or not he actually did enter guilty pleas in those cases. But if there is not, then I think we'll just move on, I suppose, to what the arguments are going to be.
That's fine, Your Honor. I've looked myself, and I have no dispute. I don't dispute what Ms. Gardner has said. In terms of argument on my end, Your Honor, I've spoken to Mr. Horton earlier. He has a desire to attend rehab. He feels like a treatment or rehab of some sort. He feels like his substance abuse issues have affected these crimes that he has pled guilty to, and he feels like he needs help to get his life back on track. So I would ask in lieu of revocation. Also, I would point out, Your Honor, the last time we were here over a year ago on revocation, the only issues he's had since then have been these new arrests. There's not been any issues of absconding that I'm aware of, or anything of that nature, which was an issue in previous revocations. So I would ask in lieu of revocation that he be given a sanction linked at the court's discretion, and we have Bethany evaluate him for possible substance abuse treatment, and that be part of his new bond conditions.
All right, Ms. Gardner.
Your Honor, in looking at Mr. Horton's history, it's very concerning, especially the case that we're asking him to be revoked, and there was an assault fourth in that one as well that he pled guilty to. Looking at his history, he's had 8 different assault charges, 7 of which are domestic violence related. He had 7 guilty pleas in his history to violation of an EPO DVO. What is especially concerning to the Commonwealth is that the victim in these 2 recent cases is the same victim in this case that he's on probation for. It's very concerning that there continues to be issues of domestic violence. Mr. Horton's taken responsibility. He's pled guilty. He admits to the conduct. And I think by virtue of these charges, it just shows he is a danger to the community. It has been an issue over the course of this probation. And based on these charges, the fact that he is going to have a new felony case in Barron County because he's had so many of these offenses within 5 years, I think his probation needs to be revoked.
Yeah, I mean, we've had, I don't want to put a made up number on it, but we've had 3 or 4 prior motions to revoke probation in this case, in addition to the times that there were bond revocation issues before the case was resolved. It seems like they're always there's always some element of assault or domestic violence or violating a protective order. And, while I would not deny that there could be a substance abuse component to that, at the end of the day, that's just multiple, that's a pretty good example of being a danger to the community when, there's all of these different assault charges and convictions that are coming out of it. So, right now, while I agree that there might have been a year or so, maybe from February or whatever it was of 2020 up to now, that there hadn't been additional charges. There had been multiple issues prior to that. And then, this is 2 convictions, like I said, for assaultive or at least violating a protective order type of issues. And it's hard to escape the conclusion that supervision in the community has been unsuccessful. In addition, that those failures are, presenting a danger to members of the community. I think under the circumstances, it is appropriate for the court to grant a motion to revoke probation that the Commonwealth filed.
Can I speak, Your Honor?
I will. I'm sorry?
Can I speak, Your Honor?
Okay.
The reason that a lot of those 4th degree I pled guilty to, I didn't do. I mean, she came and the one that's pending and already told the prosecution that I didn't do it. I don't know why they amended it up to when the COVID was going on. And this last one, the only reason I pled guilty to it is because that they said they was going to keep me in jail to September to a court date and wouldn't modify my bond. The reason why I pled guilty to a lot of these, we were living together for over a year on this last one. And the reason the law showed up is because our people we were living with all the 911 hanging up, they didn't even know how to keep people on.
Well, I mean, I don't know, what the Commonwealth's entitled to rely on, and what I'm relying on is the fact that of record, there are those convictions. Okay. I mean, and that's, your understanding or your reasoning or whatever. I mean, at the end of the day, what you did was go in there and admit that you had committed those offenses, and you've been around a long time and I have too. And this was a common theme in district court in the, back in the late 2000s and early 2010s. I mean, it's not like I've forgotten all that, it's been a persistent problem for years. And, at this point in time, it does not seem to me that it's reasonable for me to suspect that problem is going to solve itself. Supervision in the community hadn't done the trick. So I'm going to grant the motion. Okay. All right. Thank you.
Can I ask a question before I leave?
Yes.
More probation goes in revoke my probation. Does that become eligible for parole by chance?
You were cutting out. I didn't hear you.
If when I revoke my probation, does that make me eligible for parole by the time that I've got in on this case? I mean, I just wondering. I didn't know how it worked.
I do not know about you will be a state inmate. So your parole, that's when parole eligibility starts to become, an issue, but I can't tell you that you're eligible for parole right now because I don't know how much credit you've got or anything.
About 8 months in on it already or something like that, 8 or 9 months anytime. So
yeah, I mean, as soon as they get you in there and start, they'll do a time calculation on that, and they'll send you a letter or notify you.
What's the time frame on it? Does anybody know right off? Do you know what it is? I didn't know if you did or not.
No, I don't. I don't.
I didn't know. I knew if anybody knew. If I talked to anybody knew what they were talking about, I talked to you. You'd have the time to talk about it. I thank you, sir.
Right. See you.
Yes, sir.
Who's up?
I've got Thomas Dobson, Wagner, and Justice. I mean, they're all Julies. So choose what the one you want.
We'll just, Ann says we're going alphabetical. Dobbs.
Okay.
Ms. Atkins is your witness. She is under oath.
Julie, will you state your name for the record?
Julie Atkins
And where do you work?
with the U-Turn program.
And are you currently supervising a Thomas Dobson for his bond?
I am since May the 30th of 2019.
And did you send the court and myself a letter dated January 24, 2021?
I did.
And did it detail possible violations of his bond by Mr. Dobson?
Yes, on January 13, I'm sorry.
I said, and what were they?
On January 13, we called Mr. Dobson in for a random screen. He agreed to test this date. We spoke with him, but he was a no-show. Again, on January 21st, we called both numbers provided by Mr. Dobson, and we left voicemail messages at each number. And again, he was a no-show for those tests.
He has not been compliant with his testing requirement.
That's right.
No further questions.
Mr. Spears?
Ms. Atkins, in the time period between the last time we were here and these two no-shows, had you had any issues with Mr. Dobson not showing up or testing positive, anything of that nature?
No, I think the last violation we filed was in June. We did have a couple, 3 months where we were not testing because of the COVID restrictions.
Okay. And I might have missed it, but what was, you have his number and another number, is that correct? Was that the one you attempted to call?
We have, give me a second real quick and I'll check his information, okay?
Okay.
Had several numbers for Mr. Dobson, but we always have Shirley, his girlfriend, that we check with. Let me pull his case up here. We have his cell and we have Shirley, his girlfriend.
Okay. No further questions, Your Honor.
All right.
Ms. Atkins, I'd like to follow up in just a second. You stated that between June and January, that there was a period of time when you were not testing.
That's right. That's right. Because of COVID, we did not test in November and December and part of October.
Okay. So not including those times, were there any other times that he came in from June till January that he tested negative?
Let me check. And there was also a period of time in September when we weren't allowed to test as well. Scroll down. We called him August 17th. He came in. We called him September 10, and he was clean. We called him October 23rd. He said he was in Texas that date, and we asked him to provide proof, but we didn't get any proof, but we did not report that. And then we had the January 13 and January 21st dates where he was a no-show.
No further questions.
Recross?
No, Your Honor.
All right. Anything else from the Commonwealth?
No, Your Honor.
Mr. Spears?
Your Honor, I'd call Mr. Dobson.
Mr. Dobson, raise your hand. You swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right.
All right, Mr. Dobson, you heard the testimony of Ms. Atkins. Can you explain to the court from your perspective about what happened, why you missed these 2 drug tests in January?
I've never was contacted because I didn't have a phone at that time. Everyone who had my phone had been using it without my authorization because it had been stolen. And it was the company I had my service through did trace it to Texas at one point in time, but I'm not sure when it was. And I just got my phone back 6 days. I've been in here for 14 days. Add 6 days of that, I just got my phone back 20 days ago. So if they had tried to contact me, I would not have known about it.
All right. If you were to get out, you have a phone that Miss Atkins can reach you at, correct?
Yes, sir.
All right.
I have a new phone now, which is the same number.
Okay.
As the other one was.
Did your girlfriend inform you that Miss Atkins had attempted to call her or anything of that nature?
No, sir, she did not.
All right. No further questions, Your Honor.
Mr. Gardner?
No questions.
Okay. So is what you're telling me is that when Miss Atkins says they called and talked to you and you agreed to come in, that wasn't you?
No, sir, that was not me because I did not have a phone at that time.
All right. And then you say you got your phone back 20
days ago today. I got it. I had it 6 days before I got locked up, and I've been locked up for 14 days.
All right.
So it'd be 20 days ago.
So one of these times that they attempted to contact you was less than 20 days ago. Do you understand that?
If it was less than 20 days ago, I've been in there since then.
No, you said you've been in there 14 days. You got your phone back 20 days ago.
I had it.
They tried to contact you was about 17 days ago.
Well, I did not know about that.
Okay.
If you
Anybody got anything else?
That's all the proof I have of this argument, Your Honor.
All right. Yeah. Hit me with the arguments here.
Your Honor, I understand we've been here before with Mr. Dobson, and this case has drug on for COVID has caused this case to drag on far longer than I think any of us ever anticipated. I think we were set for trial sometime early last year, and COVID has pushed it back. I would argue in lieu of revocation that Mr. Dobson be given a sanction at the court's discretion, placed back on bond. It seems like the issue has been of late, not a failure at some occasions not to test, not that he's not showing up for all tests, or he's testing positive, or he's out here to getting new offenses. So I would just ask in lieu of revocation to be given a sanction, placed back on bond until we can get these cases resolved or get them to trial.
All right, Mr. Gardner.
Your Honor, we had a revocation hearing back in March of 2020. He was allowed to go to treatment at that point. Then June, we had another hearing. He was given a sanction. And here we are again, January of this year, and him failing to appear for testing. It's a continual problem. It's a continuous problem, and it will be as long as he's out and out on bond. We're never going to get these cases resolved unless he is in custody, not using, and we're able to communicate with his attorney, and he's able to communicate with his attorney. We're able to then communicate with them. So we ask that his bond be revoked and we move forward with this case.
Well, I mean, the evidence is strongly suggestive that, you go get tested if you're clean, if you're pretty sure you're going to be clean, and if you're pretty sure you're not going to be clean, a lot of people don't go get tested. And I mean, that's what this suggests to me. I'm going to tell you this. I agree. I mean, you know, it's every case is not the same. Don't get me wrong, but I mean, you know, it's just I feel like I'm repeating myself multiple times today at the very least. But I mean, you know, this is out on bond, and there, you know, some of these, at least one of these is a drug case. You know, there's a positive drug screen. There's a history of positive drug screens and all of that. You know, I mean, it's just not rocket surgery here. So what I'm intending to do is grant the motion that the Commonwealth has filed. I certainly, you know, he's got a pretrial. His case is set for trial in May. I mean, he's got a pretrial in May. If y'all want me to do that on, I will. If you want me to set something before then, I will, but that's up to you.
Judge, I would ask that all three cases be set sometime at the end of March, middle to end of March. Because we have that third case he was just arraigned on, I believe, last Monday. I haven't had a chance to review it, but I would ask that these be put like on the 15th or the 22nd, maybe, to see if we can see where we're at that stage at least, and just get all three of the cases together.
All right, March 22nd, 1 o'clock.
Okay.
Thank you.
Hey, Judge. Judge, can you hear me?
Do what?
Mike, we can hear you. Yeah.
Can we call Christopher Thurman real quick?
Yes.
Evening, Judge.
Judge, on Mr. Thurman, just so we know where we're at procedurally, Darlene had sent me an email while all these hearings were going on, mentioning to me that I hadn't filed any motion recently. My understanding, maybe I'm wrong, is that the last time we were here for revocation, we had continued it on the basis that he go to long-term treatment because he was saying he hadn't had the opportunity. And then I guess in the last couple of weeks, he went, but then left. And then we gave him an opportunity the last couple of days to go again, and he refused to go. If I was supposed to file a motion, I haven't, and I apologize. It was just a mix-up, I guess, between my being out and Darlene being out. I thought something had been filed. I know that the defense was on notice that what the accusations were is basically he refused your order to go back to treatment.
Can I say something?
Well, hold on. I'm gonna let you say something, but we got to kind of figure out where we're going here.
I never refused.
So is everybody else. My understanding, when I saw you a week or so ago, I mean, you acknowledged that you had not completed your treatment. You asked me to please, you know, which we talked about. Jason, I know all about it. You know, a tragic situation, and I hate that it happened. And I have my sympathies are with you. Okay, I promise.
Thank you.
And that's why I gave you I let you out for 3 days or whatever it was. But my understanding was that you were wanting to go back to treatment, because if you did that, then and completed that, which you had come really close to completing that last one, that then you would get that credit off the end of your sentence and you'd be done. And that's what I thought you wanted to do. So that's why I did Charity, I believe it was, went and found you a place to go. And, you know, I did the order for you to go. And then I found out that you didn't want to go. So that I thought we were just reviewing this today to make sure you had gone to treatment. I wasn't necessarily expecting a motion to revoke to get filed, because I thought you were going to treatment and I didn't know that you weren't going to agree.
It was the place where I just left from. I asked Charity, I said, look here, if I go back, I said, can I pick up where I left off? Because The reason why I left was because I had I had a death in my family.
No, I know why you left, but I mean, I don't know that, I can't tell them how long to,
Well,
I
I
can't
understand.
much
So,
credit to give you or whatever.
right. So I told her, she said, like, no, you had to start right back at day one. I said, well, if I had to start right back at day one, I feel that OR has given me everything they have to offer. Can I go somewhere different? Because this is where I'm at with this, Judge. I needed 30 days to complete it. I have called Dr. Bob. I have his email right here. I have finished the educational part of the program. Only thing I had left was life skills. And another reason I told Charity I didn't want to go because I wanted to talk to you first, just to see. Look, only thing left in my program was I got out March 11th. My 183 days was up. That was less than 30 days. Only thing I have left to do in the program is to go through life skills, and after life skills is to build aftercare for when I got out, for a support group for when I was released. So the only thing left in the program is life skills. All right, life skills, they offer IOP, intensive outpatient, which it's 8 months. So I was throwing myself to the mercy of the court instead of starting all the way back over, because before all this happened, I've got a pretty good job offer. First time in my life, my head's straight. I have no desire to use no more. They tested me when I come back off the furlough. I was clean. And Judge, you'll never get another dirty piss test on me or urine test. I've lost. I don't want to be the next in my family have to bury, man. And I just got a feeling I had my heart set on being out for the summer. I've lined up a good job, and I would love that opportunity, man.
Well, listen, I don't know what they were going to tell you. I thought that probably best case scenario would be to go back to the place that you had left, because if anybody was going to give you some credit or accelerate you up or whatever, it'd be them guys.
They said they was going to start. I called up there. I talked to Robert Wetzel. He's Dr. Bob. While I was out, I talked to him. I said, Dr. Bob, is there any way we can just, even if I had to do a couple extra months? He said, through the policy, he said, if you leave like that, he said, you have to start right back like the first day I got there. I said, well, if I have to start right back at day one, why go right back to somewhere? Because I've got an uncle. Any day I'm fixing to get a call on him. He got bone cancer. He got brain cancer. Well, if I lose another relative, I'm going right back day one again. It's just like, well, I've done everything OR has to offer. If I've got to go back to treatment, give me somewhere else to go. There's 100 Kentucky recoveries. But I'm just throwing myself at the mercy of the court. The only thing I had to do was life skills. I needed 30 days. Please, let me go to short-term treatment. I said 30 days. That's the 6 months required. And then are the IOP, the intensive outpatient through life skills. I want to put a Judge, I worked a good program, and
you did really good. I mean, as far as
I did. I did. I've done everything required of me. And I paid attention. I give leads. I took everything, I picked up everything they were laying down, and I'm going to apply that to my life, man, because that's the first time I ever had treatment. And I thank you for that opportunity. But just like, I never expected what happened, and it's just, it has killed me, man. Literally, that has killed me. It's Jason's brother.
I can't imagine anybody would have expected that to happen.
No, and it's just like, it's like, damn, and I was just so excited because I wasn't even going to give it to the probation officer. I was coming to see you first, and shake your hand for it. And I was just, I knew I was that close. You know what I'm saying? And I was going to get in your office somehow if I had to see you coming into work. You know what I'm saying?
All right. So listen, here we are. I'm going to have to send you.
Right.
You're going to have to go back somewhere.
Right. Anywhere but OR. Well, what about like when short-term treatments? Then IOP, because I've done what you require me to do. You know what I'm saying?
Well, if if you all think that Bethany might be able to find some other kind of option that isn't going to be the problem is, you know, you don't have much in between 28 days and
Right.
months. I mean, you know, there's just not a lot that are specifically tailored for the, I mean, you know, this situation is unique, but I mean, if she's got, you know, I know that the probation office is kind of hidebound as far as what they can ask, you know, they can put you in a 6-month program or, you know,
right.
You know, so,
Judge, Bethany can go talk to Christopher and see if she can arrange for a short-term treatment rather than 6 to 12 months.
you know, I would want it.
Is short-term going to do it?
Yeah, I would want it to be, you know, I mean, I'm not sure about this 28-day type of deal, but I guess under the circumstances, I would listen to what she might have to say. Because
Okay.
it was roughly 28 days from getting done at that other point.
I was 38 days being my 183 was up March the 11th.
Well, here's what I think she can do is talk to him and get some details about what he had left, and maybe even talk to these people over at Owensboro Regional Recovery and find out what he had left, and then see if there's a program that can kind of be tailored to get him what he had left.
The only thing left,
It might be sober living. It might be, who knows? It might be.
I was on step 10. It's like they put you through the steps. I was on step 10. You know, I was done. You know,
don't tell me. You got to tell Bethany when she comes.
Right. Hey, and Judge, just like I said, I was so excited to give it. I want, because you give me that opportunity, and I've lied to everybody in the court system but you, man. I've never lied to you, man. You know, I'm just have that most of respect for you, you know, because you've given me break after break, you know. And
well, listen, I do want you to know that I'm proud of you for coming back after that furlough, because I know you didn't want to, and being clean when you came back, because I know you probably didn't want to do that either. Well, maybe you did.
Yeah, dude, I'm done.
Yeah, if your head's in the right place. And I mean, you know, I'm trying to let you know here that you know, I mean, everybody ain't out to get you. All right. We're trying to work. This is unusual, but we're trying to see if we can figure out a way to make it work.
And I appreciate y'all, man. Really, I do. I mean, I give it my all, man. I did. I told you I would, and I did, you know.
Judge, rather than waiting 2 weeks or whatever, I'll have Bethany go up there this week and meet with him and see what she can find out from Owensboro. And I mean, they may say, oh yeah, he was close enough, we won't require the whole thing. I don't know. Yeah, I gotta say this, and I hate to be negative about it, but most of the times they require you to start from day one, just like he was saying he heard.
Sure.
When you don't successfully complete.
And that's why I'm willing to listen to other options besides that place.
Okay. But I can have Bethany check with Owensboro if that's all their only answer is that no, he has to start from day one and complete the entire program. Then she can look at other options.
Yeah, I'm fine with that.
Okay.
I mean, what I would say is, why don't we put it on for just that next revocation docket, but find out, but if she finds, you know, like we usually do, if she finds something in between there that, you know, she can get with me and, you know, y'all send Mike an email, or, you know, both of us an email or whatever, and we'll talk about it.
Okay.
Can you also send an email to Charity so she's in the loop too?
Yeah, we'll make sure, I'll try to forward it to her if they don't put her on it, but she's here listening. Yeah. I mean, you know, there's been a lot of water passed under the bridge here with Mr. Thurman, but I mean, he had made a lot of progress, and, you know, I'd like to kind of keep that momentum going in the right direction if it's possible.
I greatly appreciate you, Judge, man. I really do.
All right. All right. We'll be talking to you.
All right. Thank you, sir.
If we're going in alphabetical order, we get Justice next.
All right. Correct. All right, Mr. Gardner, who you got?
Call Julie Atkins.
Okay, Miss Atkins, you remain under oath. Right?
That's right.
All right. Go ahead, please.
All right, Miss Atkins, are you also supervising a Douglas Justice as a condition of his bond?
I have been since December 17, 2019.
And did you submit a violation report in this case?
I did on January 26th.
Okay, and could you detail to the court how you believe that Mr. Justice has violated his bond conditions?
I will. We called, most recently, we've called Mr. Justice for testing. Let me find that date. Sorry, give me just a second. We called him on January 14. At that time, his girlfriend said that he was sick. We asked her, or asked that he provide a doctor's statement to that effect. Douglas called back stating that he would bring in the doctor's statement, which we received. There were no medical reasons for him being sick. The excuse from TJ said that he was excused from work January 12 through January 15. We again called him on January 26. His girlfriend said they were in a car wreck and he was being treated for injuries. We again asked her to provide a doctor's statement. We did get a doctor's statement, very much the same as this one. It only addressed, it was very short. It said that he had been, you've been given the following instructions that do not work on January 26 or 27. I called TJ at that point and spoke with the attending physician. And she says that this note certainly does not, it was only relative to work, that it did not excuse from or would not interfere with him coming in for a drug test. So I called Mr. Justice back and said, we need you to come in for a drug test. And he just said he wasn't going to do it, refused to do it. So we have those two violations, and that of him not showing, and that has been a pattern for Mr. Justice over the course of our drug testing for his bond.
And did he also have a no-show for June 15, 2020?
I didn't, that date again? Yes.
June the 15th, 2020?
Yes, it goes back some time. He's actually tested very few times. He reported that he was being tested for COVID June 15th. He did provide proof. He was then a no-show on July 7th, August 21st, and October 27th. And then these latest two dates.
From that June 15th day, has he actually come in to test at all?
He has not.
No further questions.
All right. Cross.
All right, Ms. Atkins, in terms of the most recent missed dates, did Mr. Justice ever mention to you anything about having to quarantine or due to possible COVID exposure recently or anything of that nature?
Not since last summer.
Okay.
He has told us that a couple of times. Yes.
Okay. And you said you did speak to his physician at TJ?
I did.
Did you speak to anyone else with like any other, is anybody else outside of him and his girlfriend, like anybody from his work or anyone else that could, that knew anything about his reasoning for missing or anything of that nature?
No, Douglas has always given us, not always, let me take that back, but several times he's given us excuses for reported reasons for missing that have always been for medical reasons, and the range is car wrecks, being robbed, stolen check from his mailbox and he was attacked, and it's been several things like that, but
Okay,
there have been several stories.
understood. Nothing further, Your Honor.
Redirect?
No.
Is that it for the Commonwealth proof wise?
It is.
All right. Any proof on from the defense side here?
Judge, I call Mr. Justice.
All right, Mr. Justice, raise your right hand. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right.
All right, Mr. Justice, explain to the court the situation revolving the missed drug test starting back in June and specifically these last two in January.
I wasn't aware of anything in June. I've always, this past June, I don't think they said it wasn't possibly open. There wasn't testing for that month. And like from June, and August and October, so there's several months there wasn't testing. And then first I want to say I'm sorry to Judy and everybody about not coming in. But and then the doctor, Miss Combs, I took the COVID test both times, these last two recent tests, these last recent ones, and they would be they told me to be quarantined. She said, I guess the woman writing the note put on there, do not go to work, pending COVID results. But I don't know, it said, maybe they said it wrong or whatnot, but I was tested for the COVID. Dr. Combs told me specifically, Judge Alexander, I've always kept my word and come to court since the district court with you. I've always done this, and I've so my word, it's got to be worth something, sir, for this to be true. I promise you, Miss Combs, Dr. Combs at the urgent care told me specifically, taking the COVID test, do not go outside my house to quarantine and to treat myself as I was positive until negative test results were given to me. I don't know how come they only put on there the note for to work. My fiance dropped off the green, it was a green document in the Dropbox that said that I had taken the COVID test at TJ this last time that I was there. I don't know why they did not receive it. She dropped it off at the square in the box where Gary had told her to put it.
All right.
And my fiance, I mean, you can call her. She can testify to this right now on the phone, sir. Judge Alexander, I've been coming to your court since district court, have I not? And I have always came to court, and for this matter, I've not lied to you on that note. So my word, can you not take more charge? I can go get the note. They said when they wrote me 3 notes, no one can pick up the extra notes but me from DJ, because they done went to the medical records. My fiance tried. She dropped off the original at the U-turn this last time. you can phone her and ask her. I promise you to God. I'm not lying.
Okay.
And I was just going to say that with my upcoming surgeries, you know, I have a lot of medical issues. I am a veteran, also starting on what that weight that carries, but also I'm a veteran. And I'm telling you the truth. If you just give me like a day or two to go get these from the medical records, I don't know how come it just did they not check the outbox of the U-turn thing right there where Gary should have put it in the outbox, Julie?
We have those, Your Honor, we actually attached them to our report. We have several excuses from Greenview Medical, from Caverna, from TJ, from the Medical Center in Bowling Green. We have, over the course of the past year, we have several hospital and doctor statements that are similar, but we attached this last one to our violation report that I spoke with Dr. Combs about. We attached the last two that are not specific as to any COVID testing.
Yeah, I see them.
It's obvious, sir, if you take the COVID test to say quarantine.
Well, I mean, I think if you take a test and it's not a rapid test and they tell you to quarantine, that is what you should do. But apparently that's not what the doctor told Miss Atkins when she called her.
She must have been mistaken, Your Honor. The doctor, but I mean, I promise you, sir, I've been coming to you forever and I am not lying to you. I raised my hand to you.
Okay, hold on. Let's, any more questions?
No further questions, Your Honor.
All right. Mr. Gardner, do you have any cross of this witness?
No.
All right. Anything further that we need to hear from Miss Atkins, or I guess I think Mr. Justice asked her a question and she answered it. So I'll be willing to listen to that. I'll be willing to take that into account. I already heard it.
All right. Judge, all I have is argument, this argument.
All right, go ahead.
Your Honor, I think I understand where the Commonwealth is coming from in terms of the missed drug tests, but I will point out that Mr. Justice has not picked up any new charges since he's been out on this bond that I'm aware of, at least in the last 8 months. He's not picked up anything. He has told me when I've spoken to him that he has several medical issues, that he has surgeries scheduled coming up in the coming weeks. So I would ask in lieu of revocation of his bond that he be given a sanction and placed back on bond until we get these cases resolved. I believe we might be close to getting these cases resolved. Now that my memory has been refreshed from what was going on when Tyler had these cases, I just ask that he be given, his bond not be revoked and be given a sanction, placed back on bond.
Mr. Gardner.
Your Honor, Mr. Justice is correct that he's been coming to the court a lot. I dispute that the fact that he comes every time. There's always generally some excuse why he can't come. Is more, I guess, my experience with Mr. Justice, and I think it would be the court's experience with Mr. Justice as well. And it's just a continuous problem. I'm sounding like a broken record as well today, but it's just a continuous problem with Mr. Justice about going and showing up to court when he's supposed to, and then B, following the bond conditions that are put on him, such as testing through Ms. Atkins. If the court can think of another way to get him to do what he's supposed to do other than revoke his bond, I'm fine with that, but it's just, we don't get anywhere. We haven't got anywhere in a while in this case. And I would ask that his bond be revoked until we get a resolution.
Well, I don't know the truth about but I've been hearing that we got surgery next week. And, I've been hearing that since July. I got pre-op next week. Can't be here. got this. I don't know that any of those surgeries have happened. I'm not arguing. I mean, I ain't no doctor, so I don't know. You might need surgery on everything you own, but that's why we've never gone anywhere in these cases, is that every time we were getting ready to talk about something, we've kind of got an agreement worked out, but he needs to get this surgery done first and all this other stuff. I mean, it's just, again, in a broken record, it's just the same story. Now, I mean, today's the first time I've heard about getting hit by a hammer, but the other stories have been pretty common. This is the first time I've heard that one. But, here's what I'm going to do. Okay. Here's what I'm going to do. Just so that there is, just so that there can be a discussion and you all can tell me where we are and what the heck's going to happen. And if there's any proof of any kind of surgeries coming up or whatever, then I can get that too. I'm going to put this on for Monday. Okay. Maybe there's something, if the Commonwealth hadn't made you an offer, I'm sure they've got one lined up and ready to fire down the chute, and they can, fire it down there to you. If they have made you one.
For supervised probation, sir.
Hold on. If they have made you one, then you might have to dig around and look for it. But that's what I, feel like we need to do. And then at least you all can give me some kind of informed update on what the heck's happening and where we are, and if we got surgeries and if we're going to have an agreement and all that other stuff, then we'll talk. Okay.
Okay.
But that's
Hey,
where
Josh,
we are.
it's late. I don't remember. I think there's offers out in all the cases. Just let me know.
I'll dig through the files and let you know. I'll let you know tomorrow, John.
I understand. I never knew what the offers were, but I know there were offers back when Tyler was involved, because we actually discussed that there had been some talk about them.
I know what there was, Judge Alexander. Y'all was offering to give me supervised probation, and y'all just kept put it off in December because of COVID. You said you want to get people out of jail first or something. You put. I think they were saying you put my case off for until April for the supervised probation hearing or something like that, to that effect. But my medical records, sir, I'm the only one that can go get my medical records from TJ. If you just release me today, I'll bring them up here to you tomorrow. My word, Your Honor, I will bring them up.
Mr. Justice, here's what's going to happen. I'm putting you on the docket for Monday. I'm not going to let you out between now and Monday. Okay.
Yes, sir.
All right. And then we'll talk. Thank you.
Yes, sir.
Dion Wagner.
You can't have very many files left.
Is he still in probation?
Smarty pants. Smarty pants. So we're not doing Estill Cunningham?
No, we already, it just didn't trickle down to you. We moved it.
Okay.
Except we just moved it this morning, but I can't remember when we moved it to.
Okay.
KP will have to tell you.
Hey, Judge, before we get started, I need some clarification on something.
Okay.
Is he still on probation on 13 CR 225 and 14 CR 142?
No, he just won't pay his restitution in those cases.
I got you. Okay.
I think he might have served time on those, but I mean, once you get restitution ordered, you got to pay it, whether you serve it or not.
All right. So I was just double checking.
Yeah. So that's a legit question, but those are not technically on probation.
Okay.
The other 8 or 10 cases, however. No, there's 1, 2.
There's just 4, I think.
Are you not doing Brian Graves and Bruce
What?
Bruce Snyder and Brian Graves?
I don't know anything about those. I'm sorry. Oh, the Bruce Snyder, we're gonna have an agreement, right? Two of these are probation and two of them are bond. Is that right?
Yeah, I think so.
All right.
Aren't they all bond?
You might be right. I thought two of them were probation because I thought I saw
I think
some.
we got 3 motions to revoke bond, 19 CR 60, 18 CR 677, and 18 CR 66. And then the other case is on for a pretrial just because it was recently indicted.
Right.
Right.
Okay.
I will be honest with you. I had a stack of all these files and I opened the one that wasn't his and it said something about probation. So I was just looking at the wrong thing. Sorry.
Okay.
All right. I know I'm going too fast. What are we, are you gonna call somebody?
Yeah, call Miss Atkins.
All right, Miss Atkins, you are remaining under oath. I mean, you remain under oath from your prior testimony.
Miss Atkins, do you,
Heater in time.
in your capacity as the owner operator of U-Turn, supervise Mr. Wagner to monitor his bond conditions, drug testing?
That's right, I do.
And has he been compliant?
He has not.
Okay, could you tell the court about your history with Mr. Wagner?
I believe in reviewing his record last night and this morning, he was referred to the U-Turn program February 18 of 2020. I think Mr. Wagner has only tested one time since his referral date. We have called him since our last report to the court. I can rattle those dates off for you. We called him 7/1, 7/21, 7/24, 8/12, 8/27, 9/11, 10/21, 10/26, 1/14, and 1/20. He has never reported any of those times.
Have you had any communication with him?
We have. We've spoken always with his grandmother. When we were in court last, I spoke with him in court, and that was the best number to get Dion. That's what he gave me. And we've spoken with his grandmother several times and also with Dion. He just does not report.
Was Dion living with his grandmother?
That was my understanding. That was the best way to get him. When we were in court last, Mr. Gardner, I spoke with him in the jury box there and got that before I left the courtroom. And that was the best number to get him.
And you've either spoken to Dion or spoken to his grandmother and told him about reporting, and he's not reported.
That's right. And he's agreed to test 3 to 4 times. We usually speak with his grandmother. There have been 2 or 3 times when we were had to leave a voicemail message, or there was no answer because it was a continuous ring. But most often we spoke either with his grandmother or Dion, and he did not report.
No further questions.
All right. Cross.
Ms. Atkins, I want to specifically talk about like the October timeframe. Did you call him to come in to test in October, or were you guys not testing in October?
About half of that month, we did not. We called him in October. It was October 21st that we called. And then again on October 26th.
All right. Were you able to talk to him or his grandmother either one of those times you tried to contact him?
So in October, there was a continuous ring on the phone and no opportunity to leave a message either time in October.
Okay. So he did not provide you with any information about being a positive COVID test or anything of that nature in October?
Oh, he did not during that time.
All right. No further questions, Your Honor.
All right. Any additional questions on redirect?
No, Your Honor.
Okay. Is there any proof that you would like to put on in addition to what you have put on?
No, Your Honor.
All right. Mr. Spears.
Your Honor, I call Mr. Wagner.
Mr. Wagner, raise your right hand, please. Do you swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God? All right.
All right, Mr. Wagner, explain to the court from your perspective, what is going on with these missed drug tests and Miss Atkins' ability not to be able to get a hold of you?
Well, first, Your Honor, I'm just gonna say I'm not gonna make any excuse on my responsibilities as far as like my grandmother. She has diabetes, and she just recently got a toe taken off, and like I've been pretty much her primary caregiver. So like, and then I was working at one point in time at the beginning of my testing early days, and I had my employer to send me papers on the days that I couldn't go, I couldn't make it and stuff, and I sent them through email to Tyler, and I just gave all of those papers to my lawyer. Like I have at least 6 or 7 of those papers, with along with a number to contact him. But aside of that, like my grandmother, like I've been there taking care of her and stuff. And then the days that like I would call is the days that like I would either be at work, and then either my grandmother would forget to tell me until like the next day, or like I'd come and she'd be asleep. So then like the next morning she'd be like, hey, the drug people called, or this and that. And then like the later dates on there, basically I got indicted, and then like with the Christmas coming up and this and that, like I knew that I had that warrant. So to be quite honest with you, I was wanting to spend Christmas and New Year's with my grandmother because she's about to have another surgery. So I didn't know what time basically left I was going to, have with my grandma. So like the last little bit of that, other than me having COVID, like, I mean, I'll be honest with you, it was just me being there with my grandma and spending time with her. So I'm not gonna make no other excuses.
All right.
Mr. Wagner, if you were to be allowed to stay on bond, would you be willing to wear an ankle monitor?
Yes.
We can get these cases resolved.
Yes. Now I have a different number. My fiance, I have her direct cell phone line, so I would be able to get a hold of her directly there, and then of course my grandmother's number. But if I'm there at my grandma's, then y'all would know exactly where I was at. So.
Okay. That's all I have, Your Honor.
Okay. Mr. Gardner, any questions?
Yeah. Mr. Wagner, you are residing with your grandmother?
Yes, sir. The only times I wasn't able to get like a hold of me is when I was working and stuff. I've got documentation for all of that, but I am residing in my grandmother's. I've got the address and everything.
That's the number you provided to Julie, so the best place to reach you at?
Yes, sir. Yes, sir.
No further questions.
Redirect?
No, Your Honor.
All right. Is that it for proof?
Yes, Your Honor.
Go ahead.
Your Honor, Mr. Wagner did provide me documentation. I was unable to forward it to you due to an issue with our scanner, but he did provide me documentation of positive COVID screens in October, as well as a email from his, was also sent to you, but I'm not sure if you received it, from his employer. I don't know if you can really read that, but from his employer stating about quarantine because due to possible COVID exposure back in September. So I can provide the court that as soon as I can get a scanner that actually works, that actually let me do it. But I just argue, Your Honor, in lieu of revocation, that Mr. Wagner be placed back on probation, back on bond, with the stipulation of an added ankle monitor and heightened supervision. Hopefully, now that he has a new phone number, he can provide Miss Atkins this whole issue with him not drug testing can be a thing of the past, and he can start drug testing and remain out so he can be a caretaker to his grandmother and his as well. So I just asked for a sanction and bond to not be revoked, but ankle monitor added to the conditions.
All right, Mr. Gardner.
Your Honor, I understand what Josh is saying as far as the positive COVID test and the letter from the employer, but that does not account for Mr. Wagner only testing one time since he was referred to U-Turn since February 2020. One time. Mr. Wagner does what he wants to do when he wants to do it. And for as far as drug testing, he just doesn't do it. So I think the evidence is clear on that. I think that he's violated his bond and asked that it be revoked.
I mean, I'm not going to say the same thing that we've been saying all day long because everybody's heard it a million times. So I'm not going to say it anymore. I am going to say that the note from the employer, which I never got. I mean, if they thought they emailed it to me, I didn't get it. But, you know, we put the pretrial off multiple times in the fall and kept asking Tyler to get us some kind of proof that this stuff was going on, and we never got anything. And that's why there was a warrant issued back then. Now, maybe, you know, you can say we've got it now, and that might have solved the failure to appear problem. But I mean, he had pretrials, at least 3 pretrials in the fall, and didn't come to any of them.
He has documentation of where.
Hold on. You've already talked, okay, Mr. Wagner? He's, you know, like I said, one of them might have been documented. We were self-quarantining. One of them, but none of them were documented in a timely fashion. I mean, I'm hearing about them now in February when I needed to hear about them in September and August, but or October, whenever it was. You know, one of them might have been justified positive COVID test. All right. But still, here we are. In these 2 restitution cases, you know, the 13 CR 225, I ordered you to make your current payments in that case back in February. I think there's been 3 payments made, and then somewhere along the way, $20 got put on it. So there's been $320 roughly paid in a period of time that it should have been over $1,200 paid. You know, I don't have any choice in the world. You just testified about how much you were working and how you couldn't come to drug tests because you were working all the time. So, you know, that pretty much points out that you were working and had income and had the ability to pay, and you didn't pay. So in 13 CR 225, you know, I'm holding you in contempt of court for not paying your restitution. You also have the 14 CR 142, which you owe almost $1,000 in. Hadn't been a payment on that in forever, but because you were making payments, they were just applying it to the 13 CR case. I'm not going to find that you made 0 payments, even though you really did. I'm going to find that you didn't pay as ordered, and you know you're going to be in contempt in that one too. Now here's what do we do about it, right? Because we also have these 4 cases that you're out on bond, and you know your bond. I mean, you have bonds in those cases. When I did the warrants, I gave you bonds in those cases. You just haven't made them because they're cash bonds. And I intend to probably just leave those the same rather than do a revocation and an O bond, because I mean, if you can come up with the money, you can bond out. But we're going to set. I don't want. Listen, Mr. Wagner. I mean, you know, I say this to everybody. It's true. I got people too. I got family. We all do. I don't want you to miss out on the time with your grandmother. But man, you're putting yourself in this spot. We've been dealing with this for 3 years, and every time it's because you're putting yourself in this spot. It's not your grandmother's fault, but it ain't the rest of the world's fault either to let you get away with all this stuff because your grandmother's sick.
I understand that.
I mean, I can't just, you know, you can't have one set of rules for people with sick grandmas and one set of rules for everybody else.
I understand that.
So I'm revoking you, or I'm not revoking your bond, but I'm not changing it either. You know, you got a bond in these cases, and their cash bonds, we're going to set you a pretrial conference. But I am holding you in contempt in these other two cases and giving you a sanction that's going to, as luck would have it, coincide with the probably how far out I'm putting this pretrial conference. And then we'll now that you got the new case, there'll be something there for everybody to talk about, get them all in one place, see whether y'all have an agreement. You may not. We'll talk when we come back. All that's outside of the scope of this particular proceeding. But I'm gonna put the pretrial on for March the 22nd. All right. On the other two cases, he's in contempt of court for non-payment of restitution as previously ordered, 45-day sanction, retroactive to a date of arrest.
Did you say March 22nd?
That's what I meant to say.
Okay, making sure. That's what I heard.
I don't know if that's what I said, but that's what I meant to say.
So where would that put my bond at if you give me the 45-day sanction? I've already been in here almost a month. And the reason I didn't pay the restitution all the way is because they started taking child support out of my stuff. And then with the COVID, that's why my employer sent that paper, because like we quit working because due to the COVID stuff. It's like 10% my bond or something, if you can. I can make a cash bond if you can 10% it.
I'm not going to do that right now. I mean, I don't know. Let's see, your bond in 18 CR 66 is a $5,000 cash bond. 18 CR 676, same. 19 CR 60, 2,500. And 20.
If I come up with like $1,000, could I come up with like $1,000 and get out?
Look here, man. You asked me what your bonds were, and I'm telling you, I mean, we're not we're not bargaining. All right.
All
right. Thank you. Let's see, we got, I think I still have Vicky Wilburn on my docket. Don't I?
Yes, Judge.
What's the plan here on hers? It's a bond revocation also, right?
It is.
Let me guess. I'm going to hear from Julie.
Yeah, give me 1 second, Judge. Said. All right, I'm ready.
All right, Ms. Atkins, you're under oath.
Julie, will you state your name for the record?
Julie Atkins.
And do you supervise a Vicky Wilburn as a condition of her bond for drug testing?
I do.
And have you submitted a violation report to the court?
I did on January 27th.
Could you detail that for the court?
I can. Ms. Wilburn appeared in Barron Circuit Court on the 25th of January, and at that time, there was an active bench warrant for failing to report for drug testing previously. The court allowed Ms. Wilburn to remain on bond and directed that she report to the U-turn office that day to update her contact information. She did not report that day. She did report the following day, and while in the U-turn office, she reported that she was in need of treatment, and we talked about that. She admitted that she would be dirty for meth use that date, and she admitted that she'd been injecting for 5 years. So we talked about treatment. I gave her the treatment application, gave her the necessary information. She needed to leave the office. She agreed to complete that paperwork and bring it back that same day after talking with her family. She did not return that day. She also did not make the call that we had agreed that she would make to Park Place so that we could start the referral information. She did not make that call. We called Miss Wilburn on the 27th for drug testing. She did not report. I did speak with her by phone later that afternoon, and she had told me she didn't call Park Place, and she said that she didn't receive our message for drug testing. So I asked that she report on the 28th, the next day. On the 28th, she came in, we drug tested Miss Wilburn. She was positive for meth, and she admitted injecting the day before. So we submitted the violation report from there.
No further questions.
All right, cross-examination.
When did you start supervising her pretrial release?
She was referred initially to the U-turn office on February 17th, 2020 for random drug testing as a condition of her bond at that point.
Okay. So you've been supervising her for over a year now?
Yes, sir, I have.
And did you, was this the latest dust up here? Was this her worst problem she's had while you've been supervising her?
It is. She was in pretty bad shape when she was in my office.
Okay. She appears to be truthful with you when you ask her if she's going to be positive.
She really melted down that one day in the office on that Tuesday. Yes.
Okay. All right. Okay. That's all the questions I'd have for Ms. Atkins, Judge.
Okay, redirect.
No, Your Honor.
All right. Mr. Berry, do you want to put some proof on?
Yeah, I'd like to put Vicky on.
All right, Ms. Wilburn, raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead.
Ms. Wilburn, when you're out on bond, where are you living?
Anywhere I could, but I've recently contacted my mom since I've been in here, and my mom said I could come and stay with her. So
Okay.
if I get out, I would be staying with my mother.
You live here in Glasgow?
No, she lives in Metcalfe County, the center.
Okay. Were you working anywhere?
I was taking care of an elderly man.
Okay.
It was a private, he had asked me to take care of him, and that's what I was doing.
Okay. Do you no longer have that job, or would you no longer have that if you were out?
Yeah, I would still have it.
Okay. Okay, Judge, I think that's all I want to ask Ms. Wilburn. Oh, one more thing. How long have you been in jail since since
last Thursday.
Okay, all right. Okay, that's all I had, Judge.
All right, Mr. Gardner?
Your Honor, Ms. Wilburn, did you tell Ms. Atkins that you've been using meth via IV for 5 years? Is that correct?
That is correct. I need help.
No further questions.
Okay. Mr. Berry?
Nothing further, Judge. I would just, I'd ask that you give her a 14-day sanction on this and allow her to get back out and live with her mother make that a condition of our bond also. And obviously, Ms. Wilbur's got some real problems here that maybe we can deal with as we're going along here, or at least make an attempt to. But in the meantime, I'd ask the court to release her from jail and let her back on her bond.
Your Honor,
Is there anything you want to say?
yeah, Ms. Wilburn's obviously got a significant drug problem. I don't think 14-day sanctions, I think that's just probably just setting her up for failure. I think that probably she needs to detox, maybe in jail, and then go to a treatment place after that. If we could do I'm sure she's probably going through detox now if she's been using for IV for 5 years. And so, I would just recommend at least a 30-day sanction, and then after that into a treatment facility. And if Bethany can find something to put her into as a condition of her bond.
Well, here's the situation that, as I see it, and we've got somebody here that's gone in to see Julie and begging might be too strong of a word, but I mean, candidly acknowledging that she needs help, that she's an IV drug user, and that she wants help. Clearly, the evidence at least suggests that the spirit might be willing, but the flesh is weak, as often occurs in these drug cases, because Julie had tried to help her, and I think Miss Wilburn's heart was in the right place, but at the end of the day, she didn't follow through with what she told Julie she was gonna do, and then continued to use, before she finally came in and tested. I think she's being honest. She's standing right here telling me that she needs help. It's probably not, strictly speaking, my job to look out for her best interest, but it seems like to me that I would be feeding into her addiction problem to just turn her back out on the street where she's been essentially homeless for the last, I don't know how long. This kept happening in district court. She kept getting arrested in district court and then getting back out. I mean, I know it hadn't happened in this case, but that's because I've just had the case for 2 weeks, but it seems like to me that what the smart thing to do would be kind of, as Mr. Gardner suggested, to let her have a little bit of time to kind of let this stuff, work its way out of the system. She's got a pretrial for March 15th. I don't mind moving that up to like March the 1st, but I mean, this is a possession case, and a lot of possession cases we deal with by getting people some kind of treatment or whatever the case may be. I think that the DPA has a social worker that can go talk to her and see about helping her get into some kind of treatment, and maybe that can, we can come back and try to resolve it. But I mean, I feel like what I'd be doing if I just turned her back out on her own, I don't think she's capable right now of handling this issue on her own. And all I'd be doing would be setting her up to get in more trouble and fail. And I don't want to do that. I mean, she's up here begging people to help her, and that I'm not criticizing anybody, because I mean, you're part of your job at a before guilt has been determined is obviously to get your client out on probate or out on bond. And I've been there and I've made the same argument, but I mean, sitting where I'm sitting, it seems like to me that that she would be better off if I let her have a couple weeks, see if y'all can get this thing worked out and get treatment on the end of it and get her in somewhere and help her. That's what I'm trying to do.
Okay. Could we just
Miss
set
Wilbur,
a pretrial for a couple of weeks and I think we can go meet
yeah,
with-
I'm going to move it from the 15th of March to the 1st of March.
Okay.
So that she isn't just sitting in there, for no reason, because that's not the point I'm trying to make. I'm just trying to see if we can't get her some help. And it seems like even if y'all can't get an agreement worked out, you may be able to find some place that she can get out on bond on condition that she goes somewhere. I'm not trying to strong arm anybody, but I want to get her in someplace. And she, Julie tried and it just didn't work out because, she was out there and had free will and couldn't make herself do it. So I think this is a better way to handle it.
And,
Yeah,
and
Bethany
Judge,
can
may
find
I,
something.
and may I, while this case was in district court, and Vicky had I think there were 3 or 4 other times that we filed a violation because mostly for failing to report. It's like you said, the flesh was weak there. So she's had several times where she just couldn't or didn't come in.
Right. And I mean, it's not the end of the road for her. If we can get something done here, it'll be maybe the beginning of a road. You know what I mean? All right. All right. Ms. Wilburn, hang in there.
Thank you, Judge.
I'll see you in 2 weeks. Okay.
Thank you.
Actually, it's probably closer to 3 weeks, but I apologize. Probably closer to 3 weeks. Did we have a plea?
Yeah.
Oh, we're doing Snyder?
I was thinking that we said
Yeah.
that, but I don't remember.
Yeah, he filed the paperwork, so.
All right, well, then that ought to do it. Oh, okay, Ann's handing it to me right now. All right, this is 20 CR 51. This is Mr. Snyder. Are you ready?
Yeah.
All right, will you raise your right hand? Do you swear to tell me the truth, so help you God?
Yes.
Thank you, sir. Mr. Snyder, here is a document that is entitled a motion to enter a guilty plea. Does that document look familiar to you?
Yes.
And on the second page here, there is a signature. Does that signature look familiar to you?
Yes.
All right. Is it in fact your signature?
Yes.
This document is the Commonwealth's written offer on a plea of guilty. That's the front page. Again, there is a signature page on the back. Is that your signature?
Yes.
All right. Did you read both of these documents before you signed them?
Yes, I did.
Did you have time to discuss them with your attorney if there were questions that you needed to ask?
Yes.
All right. Mr. Snyder, are you satisfied with the amount
Yes.
of time that you and your attorney had to talk?
Yes.
All right. Do you understand that you have the right not to incriminate yourself? You have the right to a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine witnesses. You have the right to put evidence on in your defense, and you have the right to appeal. You understand those rights?
Yes.
All right. And do you understand as well that if you plead guilty today, you waive those rights?
Yes.
Do you feel like your judgment is impaired today for any reason?
No.
Do you feel like you're under the influence of anything today?
No.
All right. Mr. Snyder, do you feel like I am making you enter an agreement today?
No.
Thank you. I'm going to look at the offer from the Commonwealth. That was the second document that you and I discussed, or that I had you look at. The Commonwealth has agreed to make the following recommendations on a plea of guilty from your, on your part. Count 1, criminal abuse, first degree, victim under 12. That's a Class C felony. The Commonwealth would recommend a 6-year sentence. Count 2, 3, and 4 are wanton endangerment in the first degree, each of which is a Class D felony. The Commonwealth would recommend 5 years on each to run concurrently with one another and to run concurrently with your count 1 for a total recommended sentence of 6 years, plus the possibility of a fine and court costs. The Commonwealth would oppose probation or any request for shock probation. Is that the agreement that you understood?
Yes.
All right. Do you feel like I added anything to it?
No, that sounds about right.
Do you feel like I left anything out of it?
No.
All right. Hold on just a second. Nobody ever learned you that? Okay. Mr. Snyder, other than the Commonwealth's promise to make those recommendations, has anybody promised you anything else?
No.
Has anybody threatened you?
No.
All right. Are you pleading guilty of your own free will?
Yes.
Are you acknowledging, Mr. Snyder, to me here today that on January 20th, 2020 in Barron County, you committed the offense of criminal abuse in the first degree when you intentionally abused another person or permitted another person of whom you had actual custody to be abused, thereby causing either torture, cruel confinement, or cruel punishment to a person under the age of 12 years.
Yes,
Are you also acknowledging that under circumstances manifesting extreme indifference to the value of human life, you wantonly engaged in conduct creating a substantial danger of death or serious physical injury to 3 other individuals, which constitutes 3 counts of wanton endangerment in the first degree?
yes,
All right, Mr. Snyder, I'm going to accept today your plea of guilty. Mr. Spears, did you all discuss waiving a PSI?
We have, Your Honor, we are going to waive PSI.
All right. Mr. Snyder, your attorney's indicating that you wish to go ahead and have your sentencing today. Is that correct?
yeah, the final sentence.
Yeah, all right. We'll do that. I am going to accept your plea of guilty to count 1 as well as counts 2, 3, and 4. As to count 1, the sentence will be a 6-year sentence. Your fines and your court costs will be waived because it's not reasonable to expect that you can pay those in the immediate future. You're 5 years on each of counts 2, 3, and 4, all to run concurrently. The total will be 6 years. You have obviously some credit pre-adjudication or pre-judgment, and you will get credit for that time towards your sentence, okay?
All right.
All right. Do you have any questions?
No, that's about it.
All right. Thank you, sir.
Your Honor, may I say one more thing? Can I take the ankle bracelet? No.
No. Well, I hope so.
Thank you, Judge. Y'all have a good night.
You're not cutting me off already, are you, Bonnie?
Unless you got somebody else.
No, sir. No, sir.
No.
No, sir. What? I thought you said no, so I was leaving.
No.
All right. Thank you.
Thank you, Judge.
Judge, can I ask about 2 cases that I must have missed when I was on the phone? The first one is.
Are you joking with me?
I'm sorry, what?
Are you joking with me?
I'm sorry. I'm trying to cover court, but I also have a caseload to cover. I was on the phone.
Yeah. I don't believe any of that. Go ahead.
Mr. Cunningham, what happened with his cases?
That is a good question because we had to move it because and I'll tell you that they had